Perhaps, Lordship.
Yes, please.
Lordship, I may be allowed to mention item number 38, Lordship. And for the petitioner.
Where's the cause list? Yes.
Lordship, 38, Lordship, the leading counsel. Some difficulties, so the matter can come up next.
Excuse me. Put this one and do that. This. Oh, you do this one. It is blowing gas.
Maybe, Lordship.
Yes.
Lordship, item 38, Lordship. Lordship, if the matter can come up in the last week of the July, Lordship.
Mr. Prosecco, learned counsel for the petitioner, seeks adjournment of the case after 3 weeks. Prayer is allowed, listed accordingly.
Lordship is an interim. Can let the interim continue, Lordship.
The interim order passed earlier shall continue till the next return of the deed.
Highly obliged, Lord.
Where placed, Lordship.
Yes.
Just one item above item 38, item 37.
Yes.
This may be taken up after the vacation also.
Mr. C.T. Jamil, learned senior counsel, seeks adjournment of the case after the summer break. Prayer is allowed, listed accordingly.
Obliged.
May please, Lordship.
Yes,
I'd like to
please.
mention for item number 44 from the hearing list.
Ah.
Should we agree that this matter may be taken up after 2 weeks?
On the prayer of Mr. Limawa, learned counsel for the petitioner, learned counsel for the appellant,
Appellant, Lordship.
listed after 2 weeks.
Obliged, Lordship.
May it please your lordship.
Yes, please.
Lordship, I would like to mention item number 45 from hearing. Lordship, this matter may be come up after summer break, Lordship.
You are the counsel for the,
Respondent 1.
on the prayer of Mr. So-and-so, learned counsel for the respondent number 1, listed after the vacation.
Highly obliged, Lordship.
Yeah, please, Your Lordship.
Yes,
For sure, I beg to mention item number 22 here, pleadings are completed. So kindly list this.
let it come as per the list. As per the list.
May I please, Your Lordship.
Yes,
Your Lordship, I beg to mention item number 48. Your Lordship, let the matter come up after 2 weeks, Your Lordship. I've taken the consent from the petitioner.
MSIME, learned government advocate, 6 adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly. Okay.
Your Lordship, item number 40, 41, and 42. On behalf of Livica, let the matter come up after 3 weeks.
AIME, learned counsel, makes a mention on behalf of MS Livica, the learned government advocate, and seeks adjournment of the case after 3 weeks. Stop. The same is not objected to by the learned counsel for the petitioner, listed accordingly.
Much obliged.
May it please your lordship.
Yes, please.
Lordship, I beg to mention here in item number 36. My lord, let this matter be listed after 3 weeks, lordship.
You're the counsel for the,
Appellant, lordship.
on the prayer of Mr. So-and-so, learned counsel for the appellant, listed after the vacation. Okay.
Much obliged.
May I please, my lord?
Yes, please.
My lord, I beg to mention hearing item number 47 on behalf of my seniors and the younger. My lord, my senior is out of station, so I pray that this matter may be listed after 3 weeks.
Mr. So-and-so, learned counsel makes a mention on behalf of Mr. Sintiama, the counsel for the applicant, and seeks adjournment of the case for 2 weeks on the ground that the learned counsel for the applicant is out of station. Prayer is allowed, listed accordingly.
Duly obliged. May I please, your lord?
Yes,
Lordship, I'm appearing on behalf of my senior Mojame, hearing item 39. Kindly let the matter be listed after 2 weeks.
hearing item,
39.
Mr. So-and-so, learned counsel makes a mention on behalf of Mr. Mojame, the learned counsel for the petitioner, and seeks adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly. Okay.
May I please, your lordship?
Yes.
Lordship, I beg to mention item number 42, your lordship.
Item,
42, your lordship. Here.
ah,
Lordship, I pray that the matter be posted after 3 weeks, your lordship.
you're the counsel for the petitioner.
Yes,
On
your
the
lordship.
prayer of Mr. M. Solo, learned counsel for the petitioner, is the case after 2 weeks. Okay.
Lordship, much. For motion from the supplementary cost list, item number 62.
May it please, your lordship. By this petition, I'm seeking to quash the criminal proceeding GR 50 of 2023 pending before the JMFC PEC, as well as the connected FIR in view of the compromise which has been entered between the petitioner accused and the victim and the informants.
Yes.
Yes, the compromise is at page 18, the deed of compromise. Based on which the informants, as well as the victim and the petitioner.
What is
accused.
the offense?
The offense comes under 354C for voyeurism, 500 defamation, and 66E of the IT Act, which is violation of privacy by circulating images of the victim, which has been committed by the petitioner. Charge sheet has also been filed.
Whether victim is the complainant?
No, victim is not a complainant.
Who is the complainant?
They are the respondent number 3 to 6.
3?
3 to 6.
Let's see the complaint.
That will be at page 23. 23. These have been filed by the respondent, the four respondents, who are the representatives of their village. One is the village council chairman, one is the chairperson of the Women's Society, the other is the president of the Youth Federation, and the fourth person is the president of the Students' Union in their village.
This chairman Razazo village is also complainant.
Yes.
Where is the president, Students' Union in the agreement?
I have been informed that the person who filed the the complaint, there has been a change of guard. And the new incumbent has signed on the compromise deed. That'll be serial number 4.
Mr. L. Iralu, the learned counsel for the petitioner. The present application has been filed under section 482 of the Code of Criminal Procedure 1973. for quashing the criminal proceedings in GR 50/2023. Corresponding to Chazuba PS case number 11/2023 under section 354C/500 IPC, read with section 66E IT Act. Which is pending before the learned judicial magistrate first class. Pek Nagar. It is submitted, stop, it is new para. It is submitted by the learned counsel for the petitioner. That the deed of compromise dated 19/6/2024 has been entered between the petitioner/accused and the victim, namely MS Setsutulo Sapu. And the compromise has been witnessed by the complainants. Stop. Stop, in view of the compromise entered, executed between the complainant, the petitioner/accused and the victim. The present petition has been filed under section 482 of the Code of Criminal Procedure. Stop. Issue notice to the respondents, returnable after 4 weeks.
Your lordship may also be permitted to take steps on the response by Dusty in addition to the normal course.
MS S. Mary, Learned Senior Government Advocate, accepts notice on behalf of the respondent number 1. Therefore, no formal notice need be issued to the state respondents. Stop. The learned counsel for the petitioner shall, however, take steps for service of notice upon the state respondent. No. The learned counsel for the petitioner shall, however, serve the requisite copies of the petition to the learned government advocate within
In the course of the day.
in the course of the day. Insofar as respondent number 2, 3, 4, 5, and 6 are concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondents by registered post with AD as well as by usual process, as well as by dusty process within a period of
3 days.
3 days from today.
Your lordship, in the meantime, the criminal proceeding before the learned JMFC may be suspended.
In the interim, the criminal proceedings pending before the learned judicial magistrate first class Peg Nagaland in connection with GR 50/2022 shall remain suspended till the next returnable date.
For motion, item number 63.
Yes, please tell him to put the phone on the side. It's quite important. Please tell him to put it. Oh, okay.
May it please your lordship.
Yes,
Your Lordship, I'm for the petitioner in this instant case. Lordship, an IA has been filed by respondent number 6, Your Lordship. And then I have received, kindly allow me, Your Lordship, 4 weeks' time to file my reply.
4 weeks.
Oh, yes, Your Lordship.
4 weeks.
Yes, Your Lordship.
63, what happened?
3 weeks' time, Your Lordship. Oh. Lordship, my apologies. I've overlooked, Your Lordship. Kindly allow me, Your Lordship, 1 week's time to file my reply, Your Lordship.
not Mr. Age moment. The learned standing counsel, Gauhati High Court, Kohima bench. Stop. The present application has been filed, seeking for modification / cancellation / vacation of the interim order dated 22/4/2024 was by this court in WPC number 58/2024. Stop. Issue notice returnable in 10 days time. Okay,
10 days.
10 days, 10 days. Issue notice returnable in 10 days time. MS Santila. The learned counsel appears for the respondent number 1. And Mr. Im Timson appears for the respondent, the state respondent number 2 to 6. Therefore, no formal notice need be issued. The learned counsel for the applicant shall however serve requisite copies of the application. When?
During the course of the day.
To the learned counsel for the respondents in the course of the day. As submitted by, will you be filing any of, you will be filing objection
Yes, Your Lordship.
as submitted by Ms. MS Santila, Naksantila, the learned counsel for the respondent number 1. No, not that, sir. MS Naksantila, the learned counsel for the respondent number 1 is allowed to file objection on or before the next date fixed. Yes,
Your Lordship, if Your Lordship allows, I have a prayer to be made in the main writ petition, Your Lordship. I may be allowed to file one additional affidavit to bring on record one order dated that has been passed by the Commissioner Nagaland, Your Lordship. Order dated 12 February 2024, directing the parties to maintain status quo, and where else this copy was also
that
given.
copy is not a part of your petition.
No, Your Lordship.
Then
No,
in
Your
that
Lordship.
case, you have to amend the petition.
Your Lordship, here, here I have filed under section 16, Your Lordship, where I have submitted my appeal petition before the commission, Your Lordship.
Before the commissioner.
Commissioner, Your
Ah.
Lordship. And then the commissioner, in the meantime, during the pendency, what happened was, it was the deputy commissioner who has cancelled the pata of the petitioners. In that manner, I'm aggrieved, Your Lordship. In that way,
During the
I'm aggrieved.
pendency of your appeal before the commissioner, the
Yes, Your
deputy
Lordship.
commissioner has passed the order,
Yes, Your Lordship.
and that order has not been enclosed. Annexed.
Your Lordship, here I have, here the, on the, yes, no, Your Lordship, I have not annexed the order of the deputy commissioner, the commissioner, Your Lordship.
That is in which, writ petition 58?
Yes, your lordship. In both the writ petitions, your lordship. The writ petitioners have similar prayer.
58, writ petition. In writ petition 58. MS Naxantila, the learned counsel for the petitioner, is allowed to file additional affidavit. In closing, the relevant documents necessary for adjudication of the present writ petition. Okay,
Much obliged, your lordship.
Same order in the next item also.
same order.
Yes, your lordship.
That is 102. IA 102.
Yes, your lordship.
Yes, my lord.
IA 102 and WPC 59. Same order.
Much obliged.
For motion, item number 65.
Lordship.
Yes.
This village council order, appeal file, appeal endorsed to the Bushes Court. The Bushes Court have no appellate authority, your lordship. That's a simple point in this case.
Where is the order passed by the village council? Mr. Jamon?
Village council is at page. Page 20, your lordship. No, not 20. Page 16. Page 16, your lordship. Page 16 is in the similar language, type copies at page 17.
Well, what is this? I'm not getting it.
So the applicant, he claimed a dispute in Hovsha village. So he addressed an application to the village council of Hovsha village. So Hovsha village, by this letter, says that we are not aware of your claim, so we are returning your application to you. Effectively rejecting the application submitted by the respondent.
After this,
he filed an application to the deputy commissioner at page 18. Then in the endorsement, the lordship will see, here's an endorsement to the SGO civil at the bottom of the page by the deputy commissioner. It is dated 23/8/22. Has the lordship got that?
yes.
Then SGO civil in turn at page 20. This is addressed to the Bashi's court. The type copies at page 21. Please find here.
Just wait. Then after page 18,
Page 22, Your Lordship, is the Dubashi Court's settlement.
now where is the endorsement?
Endorsement is at page 20. This is by the SDO Civil. It is addressed to the head Dubashi of the Dubashi's Court, New Land. That copy is at page 21. Your Lordship. And page 22 is the settlement in SEMA. And page 25 is the settlement in English. Both the SEMA as well as the English are by the Dubashi's Court, Your Lordship. The English one is not a translation.
Third, Mr. A. Jumami, the learned counsel for the petitioner. Stop. The case in brief is that
It's one number 5.
the respondent number 5 submitted an application dated 29/12/2021 to the village council of Visha village, claiming a land dispute between him and the petitioner. By the letter dated nil, the village council informed the respondent number 5 that it is not aware of the claims put forward by him and returned the application, thereby literally dismissing the application submitted by the respondent number 5. Stop. Thereafter, the respondent number 5 submitted the application dated,
It is endorsed 23/8, must be on the same date.
submitted an application to the Deputy Commissioner Newland for settlement of the land dispute between him and the petitioner. The application submitted by the respondent number 5 was endorsed to the SDO Civil.
Yes, ma'am.
SDO Civil of
SDO Civil Newland.
SDO Civil Newland for necessary action. Stop. The SDO Civil Newland thereafter by the letter dated 26/8/2022 endorsed the matter to the DBS Court, this is Office Newland, for settlement of the issue. Stop. The DBS Court Newland by the settlement dated 28/11/2002.
22, my lord.
28/11/2022. Affirm the right of the respondent number 5 on the land in question. Stop. Nipara. It is the case of the petitioner that the Dubashis Court Newland has no jurisdiction to entertain an appeal against the decision of the village council of Village. Therefore, the Deputy Commissioner Newland / SDO Civil Newland could not have endorsed the appeal / application filed by the respondent number 5 to the Dubashi Court. Hence, stop. The present application under Article 227 of the Constitution of India. The question set aside, the settlement dated 28/11/2022 passed by the Dubashis Court Newland. Issue notice to the respondents returnable after 4 weeks. Mr. Imti, you are here?
Yeah, wonderful.
Yes, Mr. Imti, the learned additional advocate general accepts notice on behalf of respondent number 1 to 4. Therefore, no formal notice need to be issued. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned additional advocate general
During the course of the day.
in the course of the day. Stop. Insofar as the respondent number 5 is concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondent by a registered post,
As well as justice service.
by a registered post with AD as well as by dusty service within
Within a week.
a period of 7 days from today. Stop. In the interim, considering the submissions made by the learned counsel for the petitioner and the facts and circumstances of the case, the settlement order dated 28/11/2022 passed by the Dubashi Court Newland shall remain suspended till the next returnable date. Okay.
Much nice.
Yes.
For admission, item number 1.
This is admission. Admission. Yes, ma'am.
My lord, this is the judgment order of the disposed of writ petition. Writ petition number 105.
That's why I was actually like inquiring whether it will be proper for you to file a contempt against this order.
No, lordship, here it is only a challenge to addendum dated 19th April 2019 and only the seniority list, lordship. There is no direction as such as submitted by.
Yes, Mr. I am confused with this.
Yes, my lord. What happened was, after the expiry of the petitioner's father, he has applied for appointment on compassionate ground. Since his case was not considered, he has approached this honorable court by filing WBC number 21 of 2020. And then this honorable court, by order dated 14/2/2020, have directed the respondent authorities to consider his case as per the OM of 9/4/20, as per the office memorandum of 2015.
Within 2 months.
Within 3
Okay,
months.
just wait, let me hear.
Within 2 months.
Yes,
Within 2 months. Thereafter, what happened was a centralized compassionate applicants list was published and circulated list dated 21/3/2022, wherein the name of the petitioner was figured as serial number 66. So being that list was prepared on the strength of the addendum 9/4/2015 and OM 17/9/2015. Since the name of the petitioner was figured as serial number 966, her case has to be considered as when his turn comes. Being agreed with that list and the addendum of 2019, the petitioner have approached this honorable court by filing WBC 115. This honorable court, by judgment and order dated 5/7/2023, has quashed and set aside the seniority list of 21/3/2022, wherein the name of the petitioner was figured as serial number 66, and the addendum was not interfered, saying that since the addendum has to be considered in perspective, not retrospective. So accordingly, we have come up with a fresh list as directed by this honorable court in WBC 115, wherein the name of the petitioner is figured as serial number 2.
That's all.
so what happens to this pending contempt?
That's
Yes,
why,
my lord.
Lordship,
I'm coming to that.
Ah,
I'm coming to that, my lord. That there the petitioner's name is at figure serial number 2. Now, my lord, since the petitioner's name is at figure that serial number 2, we the department have written to the government proposing for consideration considering the case of the persons figured as serial number 1 and 2.
okay.
That is the proposal which we have written to the government for consideration. Merit, my lord. This is the
This is
letter
for which post?
to any grade.
To any grateful post?
Yes, because they cannot claim for a specific post. We have sought for approval in respect of the petitioner and the person figured as serial number 1, because that person at serial number 1 has also approached honorable court and the contempt was pending.
What is the addendum?
My lord, the addendum is at page number 6 of my affidavit of opposition, my lord. This addendum says that persons who died earlier should be considered first.
Lordship, a little explanation here. By this addendum, what happened is that the addendum says that the date of expiry be taken while making seniority list of compassionate appointment. So what has happened is the respondent government, they started listing the names of those who did not even applied for the post, and 20, 30 years back, they put it in the seniority list and placed the petitioner at serial number 66. Those who did not apply, those whose parents have died 20, 30 years back. So basing upon that, in the order, it is said that though it was not, the addendum was not interfered, at para 36, this honorable court has stated that, however, the manner in which the impugned addendum, this is the appointment of the first writ petition. In view of the above discussion and the law enunciated by the Honorable Supreme Court, this court is of the considered view that The addendum dated 9/4/2019 as such need no interference as this honorable court finds it to be a reasonable one. However, the manner in which the impugned addendum dated 9/4/2019 has been sought to be implemented is unacceptable.
Your seniority at serial number 66 was quashed
Yes, Lordship.
without interfering with the addendum.
Yes, Lordship.
Now they have revisited your case
Yes.
and you are now placed at number 2.
Two,
And
Lordship.
the government has sent a proposal to
Yes,
to
Lord.
consider your case
Exactly,
for
Lordship.
appointment.
Lordship.
Are you not satisfied with that?
Lordship, my father died in 2016.
No, it's
so-
all right. We understand. But
Lordship,
since
what-
now the government has actually taken up your case
Yes.
on a serious note.
Yes, Lordship.
And by actually after the court has set aside the order placing you
Order.
at serial number 66.
Lordship.
They have revisited everything and then they said, okay, by going by the addendum, you will be at serial number 2.
Lordship.
And your case has been forwarded to the government for consideration.
Yes,
I
Lordship.
think you should be satisfied, Ms. Tafi.
In that matter, Lordship, just the contempt be just pending.
It's all right. We will keep the matter.
Yes,
pending.
yes,
We
Lordship.
will give time to the,
Because
yeah,
My lord,
Ms. Ali, you are appearing for?
Yes, I'm appealing for respondent number 2. My lord.
Two is?
No, my lord, what happened is the person figured is serial number 1. He has also filed a contempt petition.
Yeah.
This honorable court in another contempt petition.
Yeah.
Those contempt petitions basing on the corresponding letter of 4th June.
Okay, but actually maybe the petitioner therein was more generous. Here, the petitioner wants the matter to be kept pending so that at least maybe
No, but from the side of the,
Because
from the
until
side of the
unless-
contempt, madam, from the
he
spot-
desires that the government should actually
But
comply.
the government is not a party. I am the contempt respondent number 2 is DGB.
Yeah, but you have
So-
forwarded the matter to
Yes.
the government.
Yes, so it is up to the government now. So from my side, we have done our work. Well, it is
Lordship,
up to
what
the
has
government
happened
now.
is the other ones submitted application only in 2022. What happened after? Yes,
No, no,
it
no.
is in the record. And I was the only one who submitted
no.
an application.
We will keep the matter pending. Maybe we have two different set of petitioners.
Yes, but just.
One willing to withdraw, one willing to.
No,
keep
it
the
was
matter
not withdraw, it
pending.
was. But my lord, what happened is, my lord, see, the contempt number 2, he is already forwarded to the government. It is up to the government
Who
now.
is the condemner number 2?
DGB, my lord. The department has already taken initiative, directorate has already taken the initiative, my lord. So no point keeping, it's up to the government now.
No, Lordship, but they are the appointing authority and if they say like that and if the government keep pending 2-3 more years, Lordship, where will the petitioner go to seek justice?
You just read the para 37 of this, the order passed in, the judgment passed in 115. In the result, this writ petition is partly allowed and disposed of with a direction to the respondent authorities
Yes,
to
Lordship.
strictly follow with the provisions of the office memorandum dated 17/9/2015 scheme for compassionate appointment in the state and the addendum dated so and so, which is to be implemented and followed prospectively and to comply and publish a fresh compassionate appointment applicants list.
Yes. So we have come with a fresh applicants list, wherein the petitioner's name is figure number 2. And we have already sent proposal for consideration of his case.
It is
So
up
it's
to,
not that we're not complying with this, the direction of this honorable court, madam.
Yes. We are closing it.
Lordship, and in that case, if the government takes time and if the petitioner's case is not considered, what will be the option, Lordship?
You can come again.
Lordship, that will be a multifarious litigation because
You
even in the
see-
first.
You see, when the government considers your case, we will first have to see whether actually the consideration given by the government is reasonable or not. If it is reasonable and if you are not appointed, maybe the government has a case. And if you're still agree, you have to come before this court. Anyhow, Mr. Ali, let us give one more chance. Since the counsel for the petitioner is quite reluctant to
Lordship, if the contempt is kept pending, at least it can pressurize them to pressure the government. The
No,
pre-
no, no,
the re-
no,
Now we have no role because we are.
In fact, what Mr. Ali says, what he submits is right, because actually the government, the respondents, they have already complied with the direction passed by this court in this judgment. So substantial compliance, so.
To consider the case within 2 months, there
What is the
no-
meaning of to consider? To consider means it's not mandated. There is no mandate, it is not mandatory to appoint you. To consider in terms of the law. Anyhow, we keep it just for 3 weeks' time.
Lordship.
Next time, come prepared for disposal. Today, we are just going to actually submit, accept your submissions, but next time, I think there is compliance of the order passed by this court. Third, MS Zajimomi, the learned counsel for the petitioner, and Mr. N. Longkama, the learned counsel for the respondent number 2. Correct? Respondent number 2.
Yes, yes, ma'am.
In terms of the judgment and order dated 5/7/2023 passed by this court in WPC 115/2022. The department has prepared the list of compassionate application from 2016 till date within bracket pre-PNER addendum dated 9/4/2019, close bracket, in which the name of the petitioner for compassionate appointment is shown in serial number 2, correct?
Yes, ma'am. Yes, ma'am.
The respondent number 2 has also written the letter dated 4/6/2024 to the Home Commissioner seeking the government direction / approval for appointment of the respondent number 2 on compassionate ground. This court, considering the list of the compassionate application in which the petitioner is placed at serial number 2, and also considering the letter dated 4/6/2024 written by the respondent number 2 to the Home Commissioner. Is of the view that the order passed, the judgment and order passed in 5/7/2023. The judgment and order dated 5/7/2023 passed in WPC 115/2022. Is already complied with. MS Zajimomi, the learned counsel for the petitioner. However, submits that he may be allowed some time to address the court on the issue. Prayer is allowed. Listed again on 25/7/2024. On that day, you come and address this court. If not, I think we'll close this contempt. Even
Lordship,
in
I
your
also-
absence.
I also have to see whether there are some compassionate appointments are made.
Those things are different. Those things are separate specifically for this
Lordship,
case.
One aspect is that appointment in constable post and all, they don't need.
You cannot bring everything under the sun in this case.
My lord,
If you have grievances in some other cases, that will be a different course of action.
my lord, my name may be deleted from the title of the cause list because I was representing TJ Longambar, the former TGP in the writ petition.
Okay,
as well
okay.
as-
Let DJ Longkumar remain in the list. Okay. That's all.
Obviously.
So on 23rd, you come, because this court has made up his mind to actually dispose the case on 23rd, even in your absence.
For admission, item number 2.
Please, Lordship.
Yes.
I'm appearing on behalf of Mr. Limatushi, Learned Counsel Limatushi, who is unwell. Therefore, he instructed me to pray for 3 weeks' time.
Mr. Senso makes a mention on behalf of Mr. Aila Matushi, the learned counsel for the petitioner, and seeks adjournment of the case for 2 weeks on the ground that the learned counsel for the petitioner is indisposed. Prayer is allowed, listed accordingly. Have you completed the pleadings?
Lordship stay has already filed, Lordship. And I'm,
And anybody?
and I'm appearing on behalf of Digimon, Lordship.
Pleadings complete.
Lordship, I have no idea, but as far as I know, the petitioner is yet to file affidavit
How
in
do you
reply.
make that submission? I have no idea. What is that submission?
Lordship,
When you come to actually seek adjournment, at least come with proper instructions. You are not appearing before a lower court. You are coming before a high court. You cannot be so casual.
apologies, Lordship.
Okay, what was that? What was the last line? Prayer is allowed. Listed accordingly.
Obliged.
For admission, item number 3.
May I please,
Yes,
Lordship?
Mr. Fuseko.
Lordship, I'll be filing my objection today, Lordship.
Objection on behalf of respondent,
All respondents, Lordship.
all the respondents.
Lordship.
Mr. Fuseko, the learned counsel submits that. Objection on behalf of all the respondents will be filed in the course of the case. List the case of the 3 weeks.
Lordship, can it be listed on 23rd August? My senior is from Gauhati.
Listed on 23/8/2024 as requested by the learned counsel for the petition.
For admission, item number 4.
Lordship, you're also similar period, Lordship.
Same prayer.
Lordship.
Same. 23rd, here also.
23rd, Lordship. Obliged, my lord.
For admission, item number 5.
May please, your Lordship.
Yes.
Lordship, there is rectification to be made in some of the petitioner's documents as per the direction received from the state respondents. So I pray that this matter will be seen after 3 weeks.
Yes, yes, what was your submission? Status file affidavit.
No, your lordship, I'm standing on behalf of Livika. I've been instructed that petitioners are to make certain rectification. So
Any other
unless
past, any other past to that effect?
Lordship, there's a direction given to the state respondent.
Which is that direction?
21st April 2023.
21 for 2021 for 2023, 21. Twenty-one for 2023.
Yes, Lordship. There were some errors to the petitioner's father's name and his date of birth.
No, nothing of that. No such direction has been passed. Respondent number 1 prays for and is granted 3 weeks time to enable him to receive necessary instructions. That's all. Who is your senior?
His in-law him.
What is your instruction?
Lordship, there is some rectification to be made to the petitioner's documents. To some of the petitioner's documents. There are some errors in the father's name and DOB of the petitioners to be corrected in the PIMS of the petitioner.
Tell your senior to come.
Lordship, he's out of station. Due to
Okay,
some
we give
personal-
him time. Tell when will he be coming?
Maybe after summer break.
Okay. Listed again on. (22/7, 2022). So as to enable the learned counsel for the petitioner to address this court. Okay.
For admission, item number 6.
Yes, Lordship.
Yes.
Lordship, this honorable court by order dated 18/6/2024 directed the respondents to file the compliance affidavit, Lordship.
Yes, Mr.
Affidavit has been filed, Lordship. However, not the compliance affidavit, Lordship. Lordship, may kindly come to pitch.
The petitioner may also implead the new incumbent holding the post of
Lordship, I filed my application for employment this morning, Lordship. However, Lordship, before the Lordship, may kindly come to page 11 of the affidavit. Filed by the respondent, Lordship.
Which page?
Page 11, Lordship.
Hmm.
This is the clearance of BN and Department, Lordship. The matter has been examined and we complete clearance for creation of 43 most of various categories of various grades for facilitating the regularization of 43 work charge employees who had completed 30 years or more continuous service under Works and Housing Department. See details below. The writ petitioner name is its serial number 19.
Serial number?
19. 19, Talijuwa. He was the writ petitioner, Lordship. So, Benard Department clearance has already been completed for creation of 43 posts. Lordship. And page 13, Lordship. This is the clearance of the Finance Department. For creation of 43 posts for regularization. Now, as per the office memorandum of 2017, Lordship, after the clearance of the Finance and BNR Department, the matter should be put up to the Cabinet for final approval. However, Lordship, instead of forwarding it to the Cabinet, Lordship, we kindly come to page 15. Different procedure has been adopted by respondents. And page 16 also, Lordship. Resubmission of proposal, one after another later, Lordship. And finally, page 17, Lordship. Again, another proposal. After clearance of the Pioneer Finance last paragraph is important, Lordship.
Let us say what was the order alleged to have been
My
violated.
Lordship, page 24 of my contempt petition.
Page 24.
Page 24. Lordship, come to paragraph 6, relevant part. Page 26.
Mr. Wati,
Yes, Lordship.
what is the order alleged to have been violated? Para 7, in view of what has been stated above, this writ petition is disposed of with the direction to the respondents to consider regularization of the petitioner service within a period of 1 month.
Yes, Lordship.
Ah.
1 month. The order was passed.
Nothing is mandated to appoint you for the consider your case.
What is not considered, Lordship?
Yes, government should have considered either rejecting or allowing
Yes.
his case.
Lordship,
That is what the order 18/6/2024 says. This court grants 3 weeks to the respondents for complying with the court's order. For complying with the court's order means with the order dated.
13/4/20.
Yes.
Lordship, my learned friend, this order, the learned friend which he cited has to be read with the preceding order passed.
Exactly, that's what I'm saying.
No, Lordship here. The order passed on 14/5/2024, Lordship,
But what was 14/5/2024?
in my affidavit, Lordship.
This court's order?
Yes.
14/5.
Yes.
Page 8.
Page.
However, on the next day, the learner shall file an affidavit with regard to the progress of the compliance of the order.
So when the matter came up on 18/6, I could not file. I pray for time. So the court order is passed in this regard, Lordship. Now, a bit surprised to.
No, it's nothing surprising. Only thing is that you have not complied.
No, Lordship, the case of the petition is under consideration, Lordship. Now, the clearance of PNR has been taken, or obtained, finances been obtained. Yes, from the MRC, Lordship.
Thereafter, the subsequent action taken by the state respondents only shows delay.
Yes, not on time, but is under consideration, Lordship. But the presentation of my friend has twisted, as far as this one is concerned, the order of the.
He has not twisted. I have heard him. He is only saying that he is only making a submission that the government has not complied with the order dated 13/4/2022. And that is why the order dated 18/6/2024 was passed.
No, Lordship, this has to be read together with 14/5/2024, Lordship.
Mr. Kiangami,
Lordship.
you are actually making a submission as if you are giving some coaching, some tuition to school children.
No, Lordship, not like that, Lordship. But the picture.
What is the last order passed by this court? 18/6/2024. That is the last order. Thereafter.
So I filed affidavit filing the progress of the compliance of the order, Lordship.
You call your officer. We'll hear from him on the next day. You call your officer. Let us hear from him.
No, Lordship, the government is doing whatever it could. It's disposal, Lordship.
So why actually stretching? Why stretching the matter? After the approval of the PNR was taken and after the finance department has given the concurrence, why again reverting back?
No, Lordship. It is just in continuous process, Lordship.
It's not continuous.
Some 50, the ratio has to be clear up. That is only the thing. Otherwise, it's not going back to PNAR or finance, Lordship. It'll go back to now MRC, then afterwards it directly go to cabinet, Lordship. It's not going back, Lordship. Just that we are taking
that
time.
Will only materialize, I think, after you retire as a government advocate. You call the officer. Let us hear from him also.
Lordship, at least some time may be given, Lordship. Not at this stage, Lordship. Because practically, it will not be possible to.
See, you are actually trying to make a submission as if the implementation of the order dated 13/4/2022 will take such a long time. It's simple as you consider whether you have considered or not. If you have considered to regularize the service, the matter ends there. If you have considered his service, his case not to regularize, the matter ends there.
Lordship, we're going to regularize. So it's not only the case of the petition, but
is in bulk, Lordship. One case isolated, cannot be isolated alone. So we are taking all of them together. Even here, 317 of them are here, Lordship. If my lord may kindly peruse page 17, is clearly stated there.
Okay, when can you comply? Give me a date. I will note that. And after that, if there's no compliance, we'll summon the officer. The contempt has been filed for a particular case. So you have to concentrate on that particular case. You cannot put everything in that case and then make a submission saying that 371, 471 are case for regularization. That, how can this court consider that? We are concerned about this particular case. And your direction was to consider.
Lordship, in that case, 2 months time, Lordship.
Where is your affidavit? You see, you actually, I don't know why I think you do not properly advise the government. It's a very simple thing. It's a very simple thing. And there is no proper advice from you to the government. That is why the matter has been lingering on. This court has directed you to consider.
Yes, sir.
Had Mr. So-and-so, learned counsel for the petitioner, and Mr. K. Angami, learned senior government advocate for the
Respondent number 1, 2, and 4, Lord.
for the respondent number 1, 2, and 4. By the new para, by the order dated 13/4/2022 passed by this court in WPC 65/2022. The writ petition was disposed of with the direction to the respondents to consider regularization of the petitioner service within a period of 1 month from the date of receipt of the order. Stop. In view of the non-compliance of the order dated 13/4/2022 passed by this court in WPC 65/2022, the present appeal has been filed. The present contempt petition has been filed. Stop. By the order dated 18/6/2024 passed by this court in the present contempt petition. 3 weeks' time was granted to the respondents for complying with the court's order, for complying with the court's order. And the respondents were also directed to file affidavit of compliance of the court's order by the next date, failing which it was observed that the court may consider passing appropriate order. Stop. Consequent to the passing of the order dated 18/6/2024 in the present contempt petition. Who is this who has filed the affidavit? Respondent
Number one, Lordship.
Respondent number one. The
Yes,
respondent number one
2 and 4, they have retired.
has filed the affidavit dated 2/7/2024. Stop. On perusal of the affidavit filed by the respondent number one. It appears that nothing has been stated on the compliance of the order dated 18/6/2024. Stop. A last chance is given to the respondent number one to comply with the order dated 13/4/2022, passed in WPC 6/5/2022, and also the order dated 18/6/2024, passed in the present contempt petition. Failing which, this court shall be constrained to pass necessary orders, including notice of contempt. Listed after 6 weeks. Yes, yes. Excuse me for 2 minutes.
For admission, item number 7.
Yeah, please, Lordship. Lordship, this is a criminal petition filed under 482.
Have you paid?
Yes, Lordship.
Have you paid?
Yes, I've made the payment on 15th May 2024.
So have you executed the agreement to that effect?
I have not executed the agreement yet. Lordship, I have only the transfer details with me. If the court allows, I'll.
Mr. Swanso? Heard Mr. Swanso, learned counsel for the petitioner, and Mr. Swanso
For respondent to Lordship.
for the respondent number 2. In terms of the order dated to 5/20/24, the learned counsel for the petitioner submits that the amount of rupees 1,75,000 has been paid to the respondent number 2. And the agreement to that effect will be executed in a week's time. Listed after a week.
For admission, item numbers 8 and 9.
One of the pleadings are completed, or if your lordship at the time, it can be taken up for hearing.
What is the case?
Discharge. One is discharge, in one is recovery from the retirement benefits.
If you can wait.
Yes.
If you can wait. We have other matters in the hearing list. For hearing.
One of the, let it come up in the hearing list, then pleadings are completed.
It is submitted by the learned counsel for the parties that pleadings are completed, and therefore the matter can be listed for hearing. Listed for hearing in the usual course.
Much obliged.
For admission, item number 10.
Yes.
Yeah, please, Lordship. Lordship, I'm appearing on behalf of Mr. Sentiangar, who is out of station. Therefore, I'm praying for 3 weeks' time.
Cynthia Younger is the counsel for?
Respondent number 4.
Mr. Sanso. Learned counsel makes a mention on behalf of Mr. Cynthia Amar, the learned counsel for the respondent number 4, and seeks adjournment of the case for 2 weeks on the ground that Mr. Cynthia Amar is out of station. Prayer is allowed, listed after 2 weeks.
Obliged.
For admission, item number 11.
May it please your lordship.
Yes.
Lordship, a similar contempt petition has been filed by the Petitioners Association, your lordship. And wherein the state has filed an IA for extension of time for the compliance of the court's order. And this honorable court was pleased to grant 6 months times, which will elapse on in the month of September. Your lordship, so my prayer is your lordship may kindly let this matter be clapped up with contempt petition 26 of 2023, your lordship.
Is it?
It's the same counsel, your lordship, if the petitioner agrees
it?
with.
Yes, Lord.
Should we clap up?
Your lordship, because it's the same department, same prayer.
Yes.
Your lordship,
I must-
the petitioner is filed individually, so he,
Individually, but
moreover, enough time has been granted, your lordship. 6 months has been gone, your lordship, regarding this case.
your lordship, I've been informed that the petitioner's case will be taken up along with the similarly situated. Your lord,
Yes, on the submission of made by the government advocate, learned government advocate, this case was closed.
lordship. That's true, your lordship.
Should we club or not?
Your lordship, in the case, lordship, enough time may be granted, but only this be the last chance, your lordship. Since, your lordship, time has been short since 31/2024, your lordship.
How much time is granted in that case?
In that case, 6 months, 6
6
months time,
months.
yes, your lordship, your lordship. There's no.
That's it.
Page 9. Last para.
Six months, but 3 months have lapsed.
Yes, that's why, your lordship.
So
if
you
this
will be
petition-
entitled only to the remaining time.
Lordship, I'll be grateful, your lordship.
Okay,
Yes, your lordship,
not 6 months.
lordship,
So we give you 3 months time.
lordship.
Okay,
lordship,
you comply?
Lordship.
Yes. Mr. Subramoti Walin, learned counsel for the petitioner and MS Mary, the learned senior government advocate for the respondent number,
All the respondents.
for all the respondents. On the prayer made by MS Mary, the learned senior government advocate, 90 days time is granted to the respondents to comply with the order dated 33/2023 passed by this court in WPC 178/2022. It is made clear that no adjournment shall be granted to the respondents under any circumstances whatsoever. Listed after? Listed? Listed on 22/10/2024.
For admission, item number 12.
Please, Your Worship.
Yes.
I represent respondent number 2. Your Lordship, I've prepared my counter affidavit and has been sent for the donor signature.
You are the counsel for the
respondent number 2.
respondent number 2.
I kindly request.
Tusako, what is this?
Lordship, here the petitioner has filed his quashing petition on the ground that no allegation has been made up in the FIR filed by the respondent 2. Lordship, and since the respondent 3, that is the university, has not even filed any complaint or instructed the respondent 2 to file a case against the respondent 3, the petitioner, but on the FIR filed by the complainant, not against the petitioner, but against some persons who have taken money from the university. There's the respondent 3. On the investigation of the IO, it's found out that there was some money taken by the petitioner.
Respondent number 3.
3.
There are only 2 respondents.
Lordship, by an IA.
Okay.
Lordship, the Global University has been the main party, Lordship, respondent 3.
Okay.
That is a case, Lordship. So the petitioner is before the Honorable Court to quash the FIR, not the FIR, but the.
And who is the respondent number 2? Informant?
Informant, Lordship. Previous, he was a former employee of the respondent 3, the Global Open University. And now he is no more. On inquiry by the petitioners council to an RTI, was found out that the respondent 3, that is the Global Open University, has not entrusted the respondent 2 to file any case or to file any FIR against the petitioner.
Why is he here?
But Lordship, the petitioner was.
Why have you implemented respondent number 2?
No, Lordship, the petitioner number 2 has filed an FIR against some persons who have taken some money from the respondent 3, Global University. And no doubt the petitioner has also taken the money, but there was some understanding that the petitioner shall bring some funds from the center for the Global Open University, that is the respondent 3. But since the petitioner fell sick and the IO of the case on the FIR filed by the respondent 2, the IO has found out that the petitioner has also taken some money. And on that, the IO of the case has requested the magistrate to issue warrant of arrest. And that was done so. The petitioner was granted bail, transit bail at Calcutta. But since the petitioner was not keeping well, the IO has questioned her through VC, and that was granted by the court, Lordship. So in that view, since there's no case against the petitioner.
What is your prayer?
Lordship, I have not yet filed my counter.
Have you filed your wakalat nama?
Yes.
What is your name? Your name? Okay. Mr. Spencer. Learned counsel for the respondent number 2. 6 for 2 weeks' time to file affidavit in opposition. What about 3?
Lordship, I'm applying for respondent.
Any affidavit?
Similar prayer, Lordship.
Same prayer is made by Mr. Spencer, learned counsel for the respondent number 3. 3 weeks' time is granted to the respondents to file their respective affidavits.
For admission, item number 13.
May I please, Lordship?
Yes. Have you filed your reply affidavit?
No, your lordship.
File it.
Your lordship, 2 weeks, your lordship.
Mr. M. Solo, the learned counsel for the petitioner, is further granted 2 weeks' time to file affidavit in reply.
March 9th.
Okay.
For admission, item number 14.
Your Lordship, here state is yet to file affidavit, so kindly grant 3 weeks' time.
MSAIME, the learned government advocate, 6 for 3 weeks' time to file affidavit in opposition. Prayer is allowed, listed the court.
For admission, item number 15.
Your Lordship, here also state is yet to file affidavit, so if 3 weeks time can be given.
Same prayer, same prayer.
For admission, item number 16.
Your Lordship, here also same prayer, 16 to 19, same prayer, Your Lordship.
Okay. 16 to 19, same prayer. Okay.
For admission, item number 20.
May I please, Lordship?
Yes.
Lordship, I beg to mention on behalf of Tipapong, Lordship.
Yes.
Lordship, I'm yet to receive some clarifications, Lordship, so Lordship, kindly.
Have you filed your affidavit?
No, Lordship.
Have you received the Paraguays?
Lordship, I've received the Paraguay's, Lordship, but further clarifications has been sought, Lordship.
MS Swenso, learned government advocate. Makes a mention on behalf of Mr. E. Tipapong and submits that the Paraguays in the case has been received. However, further clarification is required. And therefore 6 for 3 weeks' time.
Your Lordship, let this be the last opportunity because given the number of adjournments sought by the respondents.
3 weeks' time is granted to the respondents on the ground that no further adjournment shall be granted and any adjournment shall be subject to cost.
There is an interim that may be extended, Your Lordship.
The interim order passed earlier shall continue till the next returnable date.
Much obliged. For admission, item number 21.
Please, Your Lordship.
Yes.
My Lord, I have received the affidavit of the state a few days back. State is raising the issue that MOD is not a party. Although MOD is already a party, Your Lordship, here one small issue is that in the contract agreement dated 18 September 2020, my Lord, the contract agreement was signed by the chief engineer on behalf of the Ministry of Road Transport and Highways. So in our petition, Your Lordship will see in the course title that we have made MOD a party represented by the chief engineer. So since MOD has already washed off its hand by the letter dated 2nd May 2024, that the work is already cancelled and the responsibility is cast upon the state to bear the responsibility, Your Lordship. So if that will be an issue, we have no issue to file an impleachment petition, Your Lordship, for making MOD a separate entity. Although in the course title it is shown as MOD, it is represented by the Chief Engineer, Your Lordship.
How Ministry of Road Transport can be represented by Chief Engineer Nagaland?
Because of the agreement, Your Lordship, the contract agreement
No,
dated
no, no,
18
but,
September
this
2020.
mode should be a separate entity.
So we have no issue, Your Lordship. We can make that. We'll make MOD a separate entity. And I may be also allowed to file the affidavit in reply to the controversial disputed questions raised by the state in the affidavit, my lord.
Affidavit has been filed by the state.
Yes, my lord.
Yes, my lord.
And you
By
want
the
to
sole
file a reply
respondent.
to that?
Yes, I replied to that as well as, my lord, an impleachment petition for making MOD a separate entity not represented by the C, my lord.
Mr. Joshua Shaki, the submits that he may be allowed some time to take steps for impleading the Ministry of Road Transport and Highway, Government of India.
As a separate entity,
separate
my
and a
lord.
necessary party,
Lordship.
and also to file reply to the affidavit filed by the state respondents. Prayer is allowed, listed after 3 weeks.
My lord. Oblige, your lordship.
Oblige, my lord. For admission, item number 22.
May I please, your lordship?
Yes.
Lordship, here pleadings are completed, so kindly list this matter after vacation for hearing.
Yes, MS Mary, pleadings are completed.
Lordship.
State will not be filing.
No, no, your lordship. Whether LCR has been called that, your lordship, I'll be relying on the LCR.
LCR has been
Yeah,
called.
your lordship.
It is submitted by the learned counsel for the parties that pleadings are completed and the matter can be listed for hearing. Listed for hearing in the usual course.
Much obliged.
Yes.
For admission, item numbers 23 to 28.
Yes, what is this matter about?
May I please, your lordship?
Yes.
Lordship, kindly grant me some time, lordship. This matter pertains to minimum scale of pay, lordship.
Have you filed your affidavit?
Lordship, I have filed, lordship.
Have you filed your affidavit?
Lordship, I have.
It is submitted by the parties that pleadings are complete and the matter can be taken up for hearing. Listed for hearing in the usual course. Okay.
For admission from the supplementary course list, item number 66.
Yes.
Lordship, I have received the affidavit filed by the government, Deputy Commissioner.
Mr. Younger, you are the petitioner.
Yes, I am not, Lordship, I'm the respondent for the Union of India.
Okay.
So, Lordship, I may be given 2 weeks time to file, reply to the affidavit filed by the Deputy Commissioner.
State.
By the state. Because, Lordship, this survey was taken without our notice, without giving information to us. We were not aware this land was.
Okay. Okay. Mr. Younger, what? Reply. The learner CGC submits that he may be allowed 3 weeks' time to file reply to the affidavit filed by the respondent number 2, that is the Deputy Commissioner, Dimapur. Prayer is allowed, listed after 3 weeks.
For orders, item number 29. 29.
May it please, my lord.
Yes, please.
This matter pertains to construction of National Highway 129A. The petitioner is claiming for land compensation and damage compensations. However, I'm yet to receive instructions, Your Lordship.
Respondent number 9. Who is respondent number 9?
Your Lordship, we were permitted to take dusty service upon respondent 9.
Have you
And
taken?
yes, Your Lordship, and we have filed an affidavit to that effect.
Who is 9?
The village council.
Why is the village council impleaded? Respondent number 9.
Your Lordship, since it's their land and also they were the ones who issued the NOCs.
Okay. By which order you were asked to serve a notice?
Your Lordship, by order dated 2/5/2024.
2/5/2020. Have you filed your affidavit?
Yes, Your Lordship, we filed it yesterday.
Yesterday?
Yes, Your Lordship.
No, it's not there. Okay. By the order dated 2/5/2024, petitioner was allowed to take fresh steps for service of notice upon respondent number 9 by dusty service and to file affidavit to that effect. The petitioner has accordingly taken steps for service of notice upon respondent number 9 by dusty service and has filed affidavit to that effect. Stop. The affidavit filed by the petitioner is however not on record. Registry to press the same and place on record. The Mr. L.T. Sanctum, the learned additional advocate general, submits that he may be allowed 3 weeks' time to file affidavit in opposition. Prayer is allowed, listed after 3 weeks.
Much.
For orders, item number 30.
Item? Your Lordship, in this matter, I'm appearing for respondent number 1. Respondent number 1. Yes, if my learned senior colleague agrees that the matter may be posted for admission hearing after 3 weeks.
Yes, Mr. C.T.
Lordship. Matter may be listed for hearing on the day of motion. Report was called for. I do not
Yes.
know whether report has been received.
No,
Yes,
it's
report
here.
has
It
also been
It's
received.
here. Okay. Mr. L. Iramu, the learned counsel for the
Respondent number 1.
respondent number 1 submits that the pleadings are completed and therefore the matter can be listed for hearing. Listed for hearing in the usual course.
Interim may be continued. Lordship.
The interim order passed earlier shall continue till the next returning date. Okay.
For orders, item numbers 31 and 32.
May I please, Your Lordship?
Yes.
Your Lordship, I have instruction to appear on behalf of respondent number 1 to 4, Your Lordship.
Respondent.
1 to 4.
Mr. Solo, what is this IA?
Your Lordship, it's for condonation, Your Lordship.
How many days? $329. You filing objection?
Lordship, I'll be filing my Vaglanama after the summer break, Lordship.
Lordship, regarding respondent number 5 and 6, Your Lordship, if I may be allowed to take steps through.
You are respondent number?
1 to 4, Lordship. I'll be appearing.
Okay, 1 to 4.
Lordship.
What about respondent?
5 and 6, Your Lordship. Lordship, if I may be allowed to take
5 and
steps to substitute notice, Your Lordship.
Substitute notice?
Lordship, in Assam, Your Lordship.
Heard Mr. Kel Solo.
Lordship.
Kel Solo, no?
M. Solo, Your Lordship.
M Solo. The learned counsel for the applicant. And Mr. Sanso, learned counsel for the respondent number 1 to 4. Mr. Sanso, learned counsel for the respondent number 1 to 4. 6 for 2 weeks time, 3 weeks time.
Lordship.
6 for 3 weeks time. To file power as well as to file written objection to the application seeking for condemnation of the.
I beg my pardon, Lordship. The appellant may be directed to serve a copy of the.
The appellant, Mr. So-and-so, learned counsel for the appellant, shall serve the requisite copies of the application to the learned counsel for the respondent number 1 to 4. Mr. Himsel. Also submits that he may be allowed to take steps for service of notice upon respondent number 5 and 6 by paper publication. Prayer is allowed. The applicant, the learned counsel for the applicant shall take steps for service of notice upon the respondent number 5 and 6 in any one of the leading newspaper and any two in any two of the leading newspapers having wide circulation in the place in which the respondent number 5 and 6 resides within a period of
2 weeks, Your Lordship.
Within a period of 14 days from today and file affidavit to that effect. Listed after 3 weeks.
Much
Obliged.
For orders, item number 33.
Please, Lordship, on behalf of Mr. Zeran Modi, this matter come up after 2 weeks. It's not filed this affidavit.
Zetan Muli is for?
All the respondents.
For all the respondents?
Except 5, my lord.
Except 5.
Yes, my lord. My lord, as per the order dated 7/6.
What about 6 and 7?
6 and 7 is.
These are all by name? Ajit Khatri
is representing all the respondents except 5. Except 5.
So what steps have you taken?
Yes, I've taken steps as per the order dated 7/6/24.
7/6? 7/6. 7/6, Mr. Sensor. Mr. How is Mr. Zetan Muli is representing number respondent 6 and 7? In person?
I don't know.
Oh, I apologize, my lord. We have a notice for the AD registered AD on 6 and 7 also.
No, this court is inquiring how Mr. Zatin Muli is representing respondent number 6 and 7, who are actually implemented by name.
Six and 7 is not yet represented.
Pardon?
6 and 7, I think it's not yet represented.
Not yet
At first,
represented.
yes, at first, he accept notice on behalf of all the respondents.
He cannot. Very casual, oh, Mr. This. Mr. Zatin Muli, just don't write, huh? Learned CGC appears for respondent number 1, 2, and 3. Learned counsel for the petitioner shall take steps for service of notice upon respondent number 4, 5, 6, 7.
Yes, my lord, I've taken steps on respondent 4, 5, 6, and 7, but 5, respondent 5 postal address.
What about
was
6,
left
7?
there. 6, 7 also I've taken steps, my lord, for AD.
Take fresh steps. Take fresh steps upon respondent number 4, 5, 6, and 7. There's nothing on record. Service of notice upon respondent number 5 has returned unserved with a remark left.
On 5, I've taken a fresh step.
You must not have taken in the proper address. Because as per the office note, respondent number 5 has left the address. You see the order dated 7/6/2024, office note dated 21, so and so reflects the service of notice upon respondent number 5 returned unserved with postal remark left.
Yes, my lord, after this order, I've taken fresh step, my lord.
In which address?
In within some referral.
Heard, Mr. So and
care
so.
of
Learned counsel for the petitioner. And Mr. Yangarwati. Learned counsel on behalf of Mr. Zatin Muli, CGC. The learned counsel for the petitioner shall ascertain the proper address of the respondent number 5. For service of notice upon the said respondents. Stop. The petitioner shall also take steps for service of notice upon respondent number 4, 6, and 7 by registered post with AD within a period of 3 days from today.
Lord, a week may be given.
Within a period of 7 days from today. Listed after 3 weeks.
For orders, item numbers 34 and 35.
May it please your lordship. Lordship, I have instruction to appear on behalf of respondent number 1, lordship. So I'll be
One.
filing, yes, I'll be filing my power after the summer break, lordship.
This application is also for, section 5.
Confirmation. Yes,
Section 5.
Limitation laws.
You're filing objection for this,
Lordship.
Mr. Sensor? Learned counsel for the respondent number 1. What about 2, 3, 4, 5?
Await service report, Your Lordship. Respondent number 2 and 3.
2 and 3, okay.
Yes, Your Lordship.
There is nothing on record to show that services are awaited. Take fresh steps,
Yes, Your Lordship.
Mr. Sensor, learned counsel for the respondent number 1. Submits that he may be allowed some time to file power as well as objection to the application seeking for condemnation of the stop. Mr. Sensor, the learned counsel for the petitioner shall also take fresh steps for service of notice upon respondent number 2 and 3 by registered post with AD within a period of
1 week, Your Lordship.
7 days from today. Listed after 3 weeks.
Lordship, the applicant may be directed to serve the copy.
The learned counsel for the applicant shall serve the requisite copies of the application to the learned counsel for the respondent number 1 within,
Today, sir. Your
in the course of the day. Okay.
Highly obliged, Lordship.
For hearing, item number 46.
Yes, Mr. TB.
Lordship.
What is the case about civil revision?
Lordship, here, the issue involved in this, Lordship, is whether the period of limitation will run from the date of the ex parte order or from the date of knowledge. That is the issue. Now,
yes.
May I take your Lordship to page 14?
What is the law? Mr. TB, what is the law? What is the law?
In my respectful submission, your Lordship, the period of limitation should run against whom the ex parte order is passed with effect from the date.
From the date of the order?
The knowledge, because he was not aware of the ex parte order, passing of the ex parte order. So only when it was brought to his knowledge, with effect from that date only, the limitation period should run.
You are the party against whom the ex parte order was passed.
Yes. And then I was not aware of pendency of the suit. Though substitute notice by way of paper publication was made, that was made at Imphal, Manipur, whereas I was in Delhi doing my business there for 7 years. That point of time, that substitute notice was made by way of paper publication. I was not aware of the nature of the suit. Now, since 2012 to 2021, when I came back after COVID pandemic, because of loss in business there, I had to close my business. When I came back to hometown, then only I came to know about the pendants of the suit and the passing of the ex parte order. Now, immediately thereafter, Your Worship, I filed an application for recalling that ex parte order. But then that has been rejected on the ground that it is barred by limitation. Now, for an order, to file an application praying for recalling an order, ex parte order, Your Worship, the relevant provision is Order 9, Rule 7, Your Worship. Now, no, there is no period of limitation is provided, but as per the Limitation Act, wherever there is no period is limitation period is provided.
3 years.
137 will apply. 137, Article 137, that is admitted. But from which date that 3 years should run? Whether it should run with effect from the date of passing of the ex parte order, or with effect from the date it was brought to the knowledge of the applicant. I'll satisfy Your Lordship with this.
Yes, yes, I'm hearing you, I'm hearing you.
That is the issue.
Okay, in brief, Mr. Longkumar, what is your case? Before starting the hearing, let me just
yes, my lord.
Have that smell.
Yes, my contention, my whole case is that, my lord, the petitioner was fully aware of the litigation. The petitioner and the respondent, they are in constant contact with each other. And then by social media also, they have the respondent have transmitted a copy of the summons which he have received, and then to that also he have replied. Now after that, after about 9 years, the petitioner is claiming that he wasn't aware of the pending litigation.
Though he has received.
Yes. And then, moreover, he said he was not in Imphal, he was in Delhi, and then after he have shifted to another place. From in Delhi also, he has shifted his residence from one place to other. But just a concocted story, my lord, without any proof. Anybody can say that I was not there at that point of time. At that point of time, I was not there. When that summons was issued, I was there. But at least that has to be supported by some documents have to be proved.
Mr. Longkumar, what is the law according to you?
Yes, my lord.
What is the law?
No, my lord, it has to be from the date of the order.
From the date of the order. Yes. Any authority?
As of now, my lord.
I think that is the issue. You have to come with authority.
Yes, my lord.
Now, Your Lordship,
Mr. TB submits that he has authority in support and he can satisfy this court. You have no authority. So what do we do on that?
Well, in that case, I will give some time so that I will place some authority to satisfy Your Lordship.
No. As Mr. TB Jamil, the Learned Counsel has submitted, simple as that.
Yes.
Whether the period of limitation, correct?
Subject to that, the petitioner was not aware. But I am saying he was fully aware.
He was aware.
Yes.
on that I will satisfy. Just because the petitioner is aware of pendants of the suit, that is not the same. I have authority, I will satisfy Your Lordship on that. And Your Lordship, in the affidavit, the conduct of the petitioner, Your Lordship, the plaintiff. Now, they said that they were good friend, they were in relation, like in contact. And the plaintiff knows that defendant, the petitioner here, is in Delhi. Now, what prevented him to make that paper publication at Delhi, where I am there since 9 years? It's not months, not days.
The paper publication was made at Delhi.
Imphal. But he knows that I'm not there. The conduct of the plaintiff. At the bar, he is admitting that constant touch. Right? But paper publication was made at Imphal.
And in the reply, they said they have blocked my they have blocked my
Okay, you come with authority, Mr. Longkumar. You come with authority.
Yes, sir.
Okay. Let us do justice to both the sides.
Yes,
You come
sir.
with
Yes, sir.
authority. Mr. TB submits that he has authority in support of his case. You also come with authority in
Yes, sir.
support of your case.
Then after vacation.
Third, Mr. TV Jamia, learned counsel for the petitioner, and Mr. N. Longcomer, learned counsel for the respondent. On the next date fixed, Mr. N. Longcomer, the learned counsel for the respondent, shall come with proper instructions to address this court on the case listed
On the 25th, your lordship, if it is convenient,
25th July,
lordship.
listed on, okay, listed on 25/7/2024. Come with citation.
Yes, my lord.
So that you can at least assess this code.
I was preparing some other side.
Okay.
And your lordship, there's another analogous matter. Where city is there, item 49.
For hearing,
Yes.
item numbers 49 to 61.
To 61, your lordship, it's a lengthy matter, your lordship.
Let's hear you. Let's hear CT. Let's hear you.
It has a met analogous. I don't know about the facts. But if city is there, maybe I'll end up adopting his
You-
submission.
You are representing the petitioner in WPC 55 to 61.
Lordship, 55 to
Correct.
55 to 60.
Yes, and Mr. TB, CT is for 49 to 54.
54.
Yes. What is the case about? What is your case, Mr. TB?
Your lordship, the matter. Petitioners are aggrieved by the removal from service.
Just one thing. Same order passed in respect of your petitioner as well as the petitioner represented by Mr. CT. Same order.
That lordship, that I will know only after his submission.
Okay, Mr. CT. We will hear you.
I'm sorry, Lordship.
49.
I was under the impression that my friend's case will take up some time.
It's all right.
Anyway, there are altogether 13 cases which are analogous, out of which I'm representing in 6 cases.
49 to 54.
Yes, and the remaining cases, my learned
I
friend is
was just
representing.
inquiring whether a similar order has been passed in all the
Yes,
cases.
similar orders.
Similar.
Facts are slightly different, but I have made a chart about the particulars of each and every petitioners. But in short, the sums and summary of the cases on the basis of an advertisement, before referring to any documents, Lordship, just a summary. On the basis of an advertisement by the School Education Department, all the petitioners, they have applied for the post and they were selected and appointed. As some are primary teachers, some are graduate teachers, like that. Now, since for appointment of the teachers, besides the basic educational requisite qualification, B.Ed and B.Lit, that means D.Lit, Diploma in Elementary Education. Those additional qualifications are required. So up to the appointment, they were made an undertaking that within 3 years' time, you should either obtain B.Ed, who are required for B.Ed, and
B.Ed is for graduates.
Yes.
Or?
Yes, higher high school and middle school, like that. And D.Lit is primary teachers, Diploma in Elementary Education.
Okay.
So that is required. And we all executed that agreement that within 3 years' time of the appointment, we will
obtain those qualifications. So as per the undertaking, the petitioners, they have applied for distance education, MUT, the courses that for B.Ed and the D.Lit. And then we were working and some inquiry was conducted. And in the inquiry, they tried to follow the procedures as laid down under the discipline and appeal rules. Lordship is very well aware about those and the government servants conduct rules. So for violation of Rule 4 of the government servants conduct rules, the show cause notice was issued, replied, and then the inquiry was conducted. In the inquiry, what happened was, we were given a questionnaire to all. So for us, 6 cases are concerned, a questionnaire was given. And we were asked to reply those questionnaires. Although we were invited to the School of Department of School Education, we were only asked to reply that those questionnaires. And then accordingly we have replied and submitted. On the basis of that, a decision was arrived so as to remove all of us from the services. So our grievances, look.
On what ground?
Yes, on the ground that certificates are found to be fake. But the impression of the petitioners were that the diploma as well as the B.Ed where we have undertaken the training, we presume that these are genuine institutes. But later on, it is found that those institutions, universities, are not recognized by UGC. So we were made to believe that those institutes are genuine institutes where we have obtained the certificates. But then later on, it was found to be not recognized by the UGC. And in some cases, especially Alila, MSOM, School Education Department has given permission to undergo the training in that particular institute also. But later on, they found out, no, this is also not correct, not the genuine institute. Whereas the permission was given by the Directorate of School Education that you undergo training in that institute. I saw permission that I want to go pursue this B.Ed in this B.Ed course in this institute. Allow me to go for it. They have allowed. Later on, they found that the institute from where you have obtained your B.Ed certificate is not recognized by the UGC. On that ground, we were all removed from service. Before coming to that, Lordship, just one instance. Out of the 6 cases, one of the cases was heard and disposed of, allowing the writ petition on the ground of violation of principles of natural justice. But liberty was given to the department to initiate fresh proceedings in accordance with law. And that is going on. So if a similar relief is also given, because we are similarly situated person, then that will serve the interests of the petitioners. And removal from service is among the major penalties. And when the major penalties are imposed, the consequences are very, very serious. Therefore, it is expected of the officials, the authorities, to conduct the inquiry meticulously in accordance with law by affording ample opportunities to all the employees' lordship. But then,
insofar as fake certificate is concerned, we cannot turn back the clock.
Actually, we were not aware that those institutes are whether genuine or not. At the time of undergoing the training, we did not know. Only later on it was found that this are genuine. That is not my responsibility. So at least we should be given an opportunity that, okay, if it is a fake institute, then I may be allowed to undergo the training in another institute also. At least the principles of natural justice demands that. So while conducting the inquiry, so as to pass the penalty of removal from service, it is
But
so harsh.
in your petition, I do not find that institute as a party. Mr. TV, have you implemented that institute?
No, your worship, no. I don't.
Why?
I have not.
No, I have not, but then, so far as my case is concerned, your lordship, more or less facts are same. The university from which I have obtained the certificate as per the verification report, your lordship, which was received from the university, which the respondent obtained from the university, your lordship, it is said that these are fake.
Fake certificate.
Fake certificate.
Not fake university.
Fake certificate. But then the fake certificate, that verification report was not furnished to us. I have a right to be furnished with all the documents on which the respondents are relying on, the disciplinary authority, that was not been furnished. And even the relevant witness has not been examined. The witness is the direct assistant director of the university who have issued the verification certificate. That is relevant. The witness also was not examined. Without examining the witnesses, without furnishing me copy of the verification report on which they have relying on, they have found the petitioners guilty for submitting fake certificates. So they also, my submission, same line on the principle of
Why
natural
the university has not been implemented?
natural justice.
Because if you are saying that the university was not registered, is not recognized, then it is for the university to come up with clear evidence as to whether they are recognized or not.
Since the casualty inflicted on us is not by the university, but it is by the Department of School
Everything
Education.
boils down to university. Everything boils down to university.
Your Lordship, here we are questioning the inquiry process, the manner in which the departmental disciplinary proceeding was initiated against us. We are questioning that. We are not questioning the university, how it ought to have been conducted, the disciplinary inquiry. At least furnish us all the relevant documents, examine the relevant witnesses. Here the relevant.
That means you are not questioning about the certificate which is fact.
The manner in which the inquiry was disciplinary inquiry was conducted, whether natural justice was followed or not.
Yes.
Okay, we are hearing you. Come.
Yes, because there is no evidence of examination of the witnesses. And if at all, they have cross-examined us or we have cross-examined, the courts will reveal what questions were put to us, what I have also questioned to them, cross-examined.
We resume it too.
And
We resume it too. We'll hear you. Yes, go. Yes, we
Yeah,
start.
please, Your Lordship.
Yes.
Since there are series of cases, let me rely on in the first case.
This 251.
WPC 251 of 2022. And so far as other cases are concerned, with regard to the facts, their educational qualification, the post they were held, and then from where they have obtained the certificate, all this, I have prepared a chart. I'll place before Your Lordship. But since the issue involved in all the cases are common, let me just refer to the advertisement, how they were
But
appointed.
I think we have to pass separate orders since the facts are different for all.
Yes.
Okay.
So for that, I have made the chart, Lordship, for easy reference of the Lordship. Lordship is with 251 of 22. That is Shrimati N. Manu. Since the basic qualifications, that is graduate, postgraduate, these are not disputed by the respondents, and that is also not an issue. Let me not refer to those qualifications, but only with the additional qualifications. And
Let
to
us
start-
come, make us submit everything. Let me
Yes.
also have the knowledge of you.
Yes. Lordship, may kindly come to page 19. That is the advertisement, how we were appointed.
The advertisement.
Page 19 is a type copy.
Page.
Since the original copy is not very clear.
Page 19.
19 in WPC 251 of 2022. This is 9th December 2011. May I read the first paragraph, thereafter may I refer to the relevant portions where we are concerned, Lordship. May I read? Applications in the prescribed format are invited from Naga indigenous inhabitants of Nagaland for filling up of the following posts of primary teachers and graduate teachers in the elementary, for filling up of the following posts of primary teachers of school education as indicated below. And then
What is this for filling up the following posts of primary teachers and graduate teachers in the elementary? For filling up the following posts of primary teachers of school education. What is? For filling up the post of primary teachers and graduates in the elementary. for
under the
filling up-
school education department as indicated. below.
You are concerned with which post?
Serial
Just in
number
this
one,
case.
primary teacher. Number of posts is 1080 and the pay scales we are not concerned with.
1080.
Yes, serial number one, primary teacher. In the box, Lordship. And then with regard to the additional qualification, towards the bottom, Lordship will come to, may kindly come to paragraph 6.
The minimum requisite qualification for primary teachers will be 10 plus 2.
Yes.
Pass with 45 marks and above from any recognized board university. Okay. The minimum requisite qualification for, so you are concerned with the minimum serial one?
No, Lordship, yes, serial one and paragraph 6, that is the preference.
Preference will be
Additional
given
qualification, Lordship.
to candidates having professional qualification of pre-service teacher education. PSTE.
Yes.
This PST preference will be given to candidates having, this is for which post? PST is for,
Primary teachers.
where is it indicated?
No, put primary teachers as well as the graduate teachers. The advertisement is common.
The preference will be given to candidates having professional qualification of pre-service teachers education.
Yes, that is for primary teachers and the P8 is for graduate teachers.
This PST is for primary.
Yes. And then Paragraph 7 is with regard to the preferences given to the few districts, especially to the backward areas. And then I belong to that. I am from Moon.
Candidates belonging to the district of Mon, which educational qualification 40% above, 40% above.
And other conditions are not that relevant, so I'm skipping the other conditions.
So this PST is for
primary teachers.
Primary teachers.
And B8 is for graduate teachers. And others are with regard to the conduct of examination, oral interview, and all these things, which we need not endorse much, Lordship. And next, Lordship, page 21, that is the appointment orders. Annexure C. This is order dated 16 March 2013. May I just read the first paragraph and then. Yes, first paragraph, Lordship. On the recommendation of the district selection and interview board, Shrimati N. Manon, daughter of so-and-so, Turupjingha, Moon, subdivision, Moon district, is hereby appointed as primary teacher in the pay pen of so-and-so, so-and-so. And then the SSA post creation order are also shown. So the petitioner is appointed on the basis of that interview and then recommended and appointed as primary teacher.
Okay.
And accordingly, page 22, she submitted training report on 23rd March 2013. As primary teacher at GPS Pokka village. And then undertaking Lordship will find at page 24. This is the type copy.
This 23 and 24 are same.
Yes, 23 is the copy which is not very clear. That's why type copy is page 24.
What is this undertaking?
Undertaking relevant portion, paragraph 4 and 5, Lordship. Paragraph 4. I shall complete B8 PST, the requisite qualification for teaching within 3 years from the date of receiving my appointment. So with this condition, they have failing to comply with the undertaking, I shall be liable to any disciplinary action deemed fit.
But you were making a submission D E something, D.
D-Lit.
What is that?
Diploma in Elementary Education.
And for which post that is required?
That is for primary teachers.
Then why here PST?
PST is also another qualification. That is also a qualification. Equivalent.
B8 PST is equivalent to?
D-Lit.
But nothing is stated here, no?
Yes. And petitioner has undergone D-Lit. Diploma in Elementary Education.
Not this PST.
Not PST.
Even that is admissible?
That is admissible. There is no dispute by the respondents also. Earlier, PST was PST. Subsequently, the nomenclature has been changed to D-Lit.
Okay. Yes, wait, let me note that. PSTE. What is that? DI?
Diploma.
No. How is that spelled?
D dot
E dot
AL dot
EL dot
ED, E capital and D small.
ED.
Like
So
the B8.
this PST is equivalent to
elite.
DL it. And there's only a change of nomenclature.
Yes. This undertaking was signed on 13 June 2012.
Okay, so here the relevant is para 4 and 5. Correct?
Lordship.
I shall complete B.Ed PSTE, the requisite qualification for teaching within 3 years from the date of receiving my appointment. Failing to comply the undertaking, I shall be liable to any disciplinary action deemed fit as a government servant. The above condition is well understood and assigned the undertaking. Okay.
Yes. Now the hot cake. That is with regard to the delete. Page 25 is the admit card in the Mewar University.
Page 25.
Yes.
DLED. This is okay.
This is the admit card for the delete.
Page 25. Okay. Just wait. This is admit card, Mewar University. Institution is right or contrary. Manual enroll numbers also to DL 2018. Examination to be held from June 12th, 2000, according to the notified. Hours from 9 hours, afternoons and so. Okay. Okay.
And the next page is page 26. That is marks come grade report. This is
Marks
the certificate.
come, okay, page 26.
This was issued on 27 September 2018. And
Just wait, Mr. Yes. So this is the Markham grade report of delete.
In other words, yes, certificate.
Department DL delete. Yes.
In the bottom of the page on the extreme left-hand side, Lordship will find a date, September 27, 2018.
Where?
Bottom on the extreme left, date September 27, 2018. Place Chitukar. Extreme left, Lordship. Page 26.
This
Down-
is
down below.
the
Down
mark
below.
grade. This is the mark grade.
Marks
come grade
report. Extreme.
Yeah,
left.
I have seen
In the
percentage
bottom.
63.88.
Yes.
What is the duration of this course? Just for my knowledge. What is the
1 year
duration
course.
of this course?
1 year course.
It's a first year as well as second year. Mr. CT.
It is 2 years course.
First year as well as second year.
Yes.
First year, second year. This is
Yes.
second year.
2 years.
Okay.
This is the final mark sheet.
Yeah, 68. Maximum First year 66.67, second year 7. Okay, GPA 13.67. Okay. Okay.
Next page is page 27 is bona fide certificate issued by the
Just wait, page 27.
bona fide certificate. This was issued on 28/2/2022. After this, the real show starts.
What is the real show?
Page 29. Under the name and style of show cause notice.
What is page 28?
28, same copy, but type copy lordship will find in the next page, page 29.
Okay.
Since the issue starts from here, I may be allowed to read the entire.
Page 29.
Yes, show cause notice dated 17 February 2022.
Dated 17 February.
Yes. It will be necessary to read, lordship.
Yes, wait. Yes.
May I read, lordship?
Please, please.
Show cause notice. Whereas a prima facie case of gross misconduct against you has been established in submitting fake diploma in elementary education, that is DLIT certificate purportedly issued by the Mewar University, Rajasthan. And whereas there is reasonable ground to believe that you have utilized fake documents and misled the department by availing undue service benefits.
For availing.
Yes. And whereas the offenses committed by you are the grave and serious nature, which viewed very seriously, as they are in direct violation of Rule 4, Clause 1 of the Nagaland Government Servants Conduct Rules 1968. Now, therefore, you are hereby directed to show cause in written within 10 days from the date of receipt of this notice as to why disciplinary proceedings should be initiated against you for violation of the Nagaland Government Servants Conduct Rules 1968. Take note that failure to comply with this directive will lead
to initiating disciplinary proceedings against you without issuing further notice. So this was issued by the Principal Director, School Education. So in response to this, the petitioner has filed her reply as has been directed by the authorities.
Yes.
And page 30 is my reply. Reply to your show cause notice dated so and so. Respected sir, with due respect and honor, I hereby reply to your show cause notice mentioned above. That sir, your high authority had issued me the show cause notice pertaining to my diploma in elementary education certificate, which has purportedly found to be fake from the Mewar University, Rajasthan. That sir, I hereby submit my statement in connection with the show cause notice issued by your high authority. That sir, as professional qualification is required for better quality education for the children, in good faith, I enrolled myself in distant education mode in Mewar University of Rajasthan, having learned from reliable sources that the Mewar University is a recognized open university, which also offered the course for D.Litt. As such, without any bad intention with my layman's view, I took up the course. I also do not have any bad intention to violate the Nagaland Government Servants Conduct Rules 1968. Therefore, sir, I hereby admit that if this certificate of my diploma in elementary education does not meet the criteria as required or found to be fake, I shall take up the course immediately as and when the higher authority has directed me to pursue. And sir, I also request that no disciplinary action may be initiated against me as I did it in good faith, but not with an intention to violate the service rule of Nagaland and the department. Thanking you, sir. And then the petitioner has said, in short, Lordship, some sense.
It's something like, I have stolen your money, but I will return back. Okay.
And the stealing was not with bad intention, but with an intention to refund it in a better time. The sums and summary of this submission is, Lordship, three things. In good faith, the petitioner has enrolled. And whatever she has done, that is unconditional. And then thirdly, the petitioner do not have any knowledge that the institute is a fake institute.
Is this a Mewar University not recognized?
They say so. They say so.
They say
Because
so.
School education, they go strictly as per the UGC guidelines. So what any institution, any university which is not recognized by the UGC. And one ground which the respondent has taken is, as per the UGC guidelines, the distant education should confine, the jurisdiction of the university should confine within that particular state, more particularly that state of Rajasthan, and they do not provide any facility for distant education. That is the contention.
No, that has been laid down by the Honorable Supreme Court.
So
Okay,
that is,
anyhow.
that is the ground. Now, since they are not satisfied with my reply, the authorities have taken a decision to conduct a proper inquiry.
Okay.
So the memorandum was served. Lordship will find it page 31, annexure I. This was, since this is the main point of contention, although the letters are small, but let us make an endeavor to read this, Lordship.
Okay.
2 pages only.
Memorandum.
This is 2nd March 2022, issued by the Principal Director, School Education. May I read, Lordship? Memorandum, paragraph 1. The undersigned proposed to hold an inquiry against Srimati N. Menon, Nagaland, under Rule 9, Clause 2 of the Nagaland Services Discipline and Appeal Rules 1967. The substance of imputation of misconduct or misbehavior in respect of which the inquiry is proposed to be held is set out in the enclosed statement of article of charge, that is annexure 1. A statement of the imputation of misconduct or misbehavior in support of each article of charge is enclosed, annexure 2. A list of documents by which and a list of witnesses by whom the article of charge are proposed to be sustained are also enclosed, annexure 3 and 4. Paragraph 2. Srimati N. Menon is directed to submit within 10 days of the receipt of the memorandum a written statement of her defense and also to state whether she desires to be heard in person. This is very important. Paragraph 3. She is informed that an inquiry will be held only in respect of those articles of charge are not admitted. She should therefore specifically admit or deny each article of charge. Srimati N. Menon is further informed that if she does not submit her written statement of defense on or before the date specified in Para 2 above, or does not appear in person before the inquiring authority or otherwise fails to refuse to comply with the provisions of Rule 9, Clause 2 of the Nagaland Services Discipline and Appeal Rules 1967, or the order directions issued in pursuance of the said rule, the inquiry authority may hold the inquiry against her ex parte. 5. Attention of Srimati. I think this will not be necessary to read, Lord, because these are all stereotype.
Just read.
And then
Just read.
the annexures are in the page 32. Statement of article.
Just read, Mr. Siki, just read.
Lordship.
Yes.
Page 32. This is annexure 1, that is statement of articles of charge framed against the petitioner. Article 1. That Srimati N. Menon, while functioning as primary teacher, violated Rule 4, Section 1, subsection Roman 1 and 3 of the Nagaland Common Servants Conduct Rules 1968. Annexure 2. Statement of imputation of misconduct or misbehavior in support of articles of charge framed against Srimati N. Menon, primary teacher. Article 1. That the said Srimati N. Menon, while functioning as primary teacher, submitted fake diploma in elementary education certificate purportedly issued by the Mewar University Rajasthan, has utilized the fake documents to mislead the department for availing undue service benefits, thereby fail to maintain absolute integrity and indulge in acts unbecoming of a government servant. Annexure 3. List of documents by which the articles of charge against Srimati N. Menon, primary teacher, are proposed to be sustained. Number 1. Letter from competent authority of the Mewar University Rajasthan certifying that The diploma in elementary education certificate submitted by Srimati Menon is fake, not genuine. Annexure 4. List of witnesses by whom the article of charge framed against Srimati N. Menon, primary teacher, are proposed to be sustained. Number 1, head teacher, GPS Puka, that is the school where the petitioner was serving. So headmaster was one of the witnesses of the department. Now, pursuant to this, since within 10 days time, I have been directed to reply. So I have submitted the written statement. Lordship will find at page 33, annexure J. So this was submitted. The date is not mentioned, but pursuant to the article of charge, the written statement was submitted by the petitioner.
Yes, please.
Let me start from the body of the letter. Respected sir, avoiding the subject. With immense pleasure and humble prayer, I hereby reply to your memorandum number so-and-so dated 2nd March 2022 for your kind favor and necessary action, please. I also hereby submit my written statement as per the direction of your proposal of article of charge framed against me, which has been marked as annexure 1. Also intend to submit my written statement in the form of annexure. Annexure 1. I hereby state that I do not have any ill motive towards the government and mislead the department. I acted in good faith. However, I apologize if my humble deed and been found to be violating any of the rules laid down by the government of Nagaland. I also hereby state that I have been sincerely rendering my services as a government servant since I was appointed as a primary teacher through competitive examination and serving till date. I enrolled myself through distant mode, that is private, to meet the requirement of the department, complying to the department's notification to complete the training course on or before March 2019. As such, in good faith, I produced the documents from the Mewar University of Rajasthan, having learned that non-compliance of the department's notification may hamper my service, which as a result, I may be terminated. I further state that I do not have any pit intention to violate the Nagaland Government Services rules, nor to mislead the department and avail undue service benefits. It is also pertinent to mention that I have already attended 38 years of age, and if I'm terminated from the service, it would not only ruin me, but the future of my children, since I am the sole breadwinner in the family. Therefore, your high authority may consider our future and give us an opportunity to undergo training as it deems fit. I also state that I desire to appear in person before the inquiry team if I am permitted to appear before the inquiry team as and when called upon. This is very important. I deserve a right to be heard in person. And then next page is not clear, so type copy lordship will find it page 35. Annexure, reply to annexure 2.
Yes, please.
I do hereby state that I enroll in the Mewar University, Rajasthan, having learned that the D.Lit course has been offered through distant mode from the reliable sources. After which I also Googled and found that the Mewar University is a recognized open university. Therefore, in good faith, I enrolled myself through distant mode with an intention to complete the course within the stipulated period of 2019. After which I submit in the year 2021. I also admit that I was misguided and misinformed by someone else to submit the said documents. Therefore, sir, I hereby state that since I submitted only in the year 2021, I have not availed undue service benefits from the department. Hence, read that I may be given an opportunity to obtain relevant training as required by the department. And before I come to the Annexure 3, Lordship, just here, I would like to highlight one point. As Lordship has seen, the department in the charge, department has categorically mentioned that you have availed undue benefit, service benefits by placing the certificate. Therefore, by cheating the department, you are liable to be punished. That was the opinion catered by the authority. But the petitioner here, she has mentioned that, look, the certificate which I have produced was only in 2021, even before the charge, after only in 2021. So over the years, from 2013, I have been sincerely discharging my duties. So there is no intention on my part to cheat and to get undue service benefits out of this. That is what the petitioner means to say this here, Lord. Responding to the charge. Annexure 3, the same page. As directed, I am pleased to hereby submit my documents purportedly found to be fake as alleged. As also mentioned in Annexure 3, to produce a certificate from the Mayor University, I could not produce as I was misguided and misled and unable to trace the person who misguided me. And then admit card is enclosed, mark sheet enclosed, which Lordship has already produced. Annexure 4, a letter from the teacher in charge of GPS Puka is hereby enclosed. So those are the documents the petitioner has enclosed. And on receipt of all these documents, the authority has taken a decision to institute an inquiry. And then the petitioner has received a notice for conducting an inquiry by a court of inquiry, Lordship. Lordship will find at page 36, Annexure K. This is with regard to the inquiry by a court, Lordship. This is 21st March 2022.
Yes.
May I read, Lordship?
Yes, please.
Whereas an inquiry under Rule 9, Clause 2 of the Nagaland Services Discipline and Appeal Rules 1961 is being held against Srimati N. Manon, PT, GPS Boka. And whereas a board of inquiry has been constituted to inquire into the charges framed against her under Rule 9, Clause 4 of the said rules. Now, therefore, Srimati N. Manon is hereby directed A, to present herself for a hearing before a board of inquiry on 30th March 2022 at 10 a.m. in room number 411, Directorate of School Education, Kohima, Nagaland, along with all documents, records, materials pertaining to the pursuing of the delete course. B, intimate the name of defense assistant if she intends to engage one. C, inspect within 5 days documents, a list which was sent to her with the charges. D, submit list of witnesses to be examined on her behalf with the address, indicate what issues you will help in clarifying. E, submit list of additional documents she wishes to have access to, indicate the relevance of the documents to the presentation of her case. So this was issued by the Deputy Director and Chairperson, Board of Inquiry on 21st March 2022. And then along with that, memorandum of 8 April 2022. Enclosed here with a copy of the inquiry report.
Yes,
Yes. That is the inquiry report.
This page 37 is, what is this? Memorandum.
Memorandum enclosing inquiry report. Inquiry report, Lordship will find in the next page.
Okay.
This is the forwarding letter whereby the inquiry report has been enclosed.
Please
Page
read this.
38, inquiry report. May I read, Lordship? An inquiry under Rule 9, Clause 2 of the Nagaland Services Discipline and Appeal Rules 1967 is being held against Srimati N. Manon, PT GBS Buka, White Memorandum, dated dated 2nd March 2022. A board of inquiry was constituted with Srimati Chris Ashom, Deputy Director, Directorate of School Education, as chairperson, and Shri P. Nilayapan, Assistant Director, Directorate of School Education, and Srimati Dalilula, Assistant Director, Directorate of School Education, as member to inquire into the charges framed against her under Rule 9, Clause 4 of the said rules, right, dated 14 March 2022. The Board of Inquiry summoned the charge Carmen Servant to present herself for a hearing before it on 30th March 2022 at 10 a.m. at the Directorate of School Education, Kohima. The statement of the charge Carmen Servant was recorded and all material documents related to the case were summoned under and examined. I'm questioning here, Lordship. As per the respondents, the statement of the charge Carmen Servant was recorded and all material documents related to the case were summoned and examined. If the statements of the petitioner is recorded, whether it is through software or they have just noted down, there has to be some record. But till then, the department is unable to show, the respondents are unable to show what are the statements the petitioner has given, which manifestly shows that they have not recorded her statement. Only the questionnaire which I have been mentioning to the Lordship has been done. Now next, Defense Assistant avail of by the charge Carmen Servant and his participation in the inquiry. The charge Carmen Servant did not avail service of defense assistant during the inquiry proceedings. The articles of charge and statements of imputations of misconduct or misbehaviors. Article of charge. Article 1. That the said Srimati N. Menon, while functioning as primary teacher, violated Rule 4, Section 1, Subsection Roman 1 and 3 of the Nagaland Government Servants Conduct Rules 1968. The statement of imputation of misconduct or misbehavior. Article 1. That the said Srimati N. Manon, while functioning as PT, submitted fake diploma in elementary education certificate purportedly issued by the Mewar University, Rajasthan, has utilized the fake document to mislead the department for availing undue service benefits, thereby fail to maintain absolute integrity and indulge in acts unbecoming of a common servant. Case of the disciplinary authority. The charge Carmen Servant submitted her statement of defense on 10/3/2022, wherein she denied the article of charge. Gist of the charge Carmen Servant, page 39. The charge Carmen Servant denied the articles of charge framed against her. Assessment of evidence, 42. The charge Carmen Servant, Srimati N. Menon, claimed that she had taken admission for the D.Litt course Mewar University, Rajasthan University in the year 2016 under distant education mode. She stated that Isaac Newton School, Dimapur was the study center and exam center for the course. The charge Carmen Servant stated that she did not attend the practice teaching program, which is the most important practical work prescribed for the D.Litt course. 44. The charge Carmen Servant could not produce copies of assessment, practical works, etc. done during the personal contact program, which are important practical works prescribed for the D.Litt course. 45. As per the National Council for Teacher Education, Regulation 2009, the university offering teacher education program through open and distant learning system will have territorial jurisdiction as defined in the Act of the University. The study center of the university shall be located in the territorial jurisdiction of the university. This is the condition. The Mewar University, Rajasthan, do not have
territorial jurisdiction outside the state of Rajasthan for offering tailored course through distance education mode. As per the National Council of Teacher Education Recognition Norms and Procedure Regulation 2009, existing teacher training institute recognized by the NCT for offering the same program in the face-to-face mode and having all the requisite infrastructure and staff as per the NCT norms and institutions, having offered the relevant teacher training course for at least 5 years duration, are only eligible to become a study center. The teacher education supervisors engaged for various activities of the study center shall be fully qualified as per the NCT norms. 47. The Isaac Newton School, Dimapur, do not fall under the above categories and could not function as a study center for DLED course offered by any university. 48. It is the responsibility of the candidate to ascertain the credentials of institutions before taking admissions and satisfy themselves that the institute university offering DLED course fulfill the norms prescribed by the Council for Teacher Education, Recognition Norms and Procedure Regulations 2009. The NCT has been issuing advisories in this regard from time to time, and ignorance of law is no excuse. 49. The verification report given by the competent authorities of Mewar University, Rajasthan, establishes that DLED certificate submitted by the church common servant, Srimati Menon, are fact. Findings on each article of charge and reasons thereof. The article of charge 1 framed against the church common servant, Srimati Menon, primary teacher, is proved beyond doubt on the basis of careful analysis of evidence brought on record before the Board of Inquiry. That is the final report that is submitted on 7 April 2022. That is the finding of the Board of Inquiry. And then the next page, page 41. Is the reply by the petitioner. Page 41. Although few points will be.
This is reply to the
memorandum.
To the inquiry.
Yes.
Findings in the inquiry.
Findings of the inquiry. With due respect and humble prayer, I hereby have the honor to reply to your office memorandum dated 8 April 2022 for your special consideration. That, sir, first of all, I apologize for all the inconveniences caused by me. Indeed, I have never intended to mislead and avail undue service benefits, but with an intention to follow the guidelines of the department. But unfortunately, I was trapped and victimized. I therefore crave the leave of your authority to please consider me under the following conditions. Number 1, that, sir, I was never intended to mislead the department and avail undue service benefits, nor I avail any service benefits from the fact DLED certificate submitted by me. I was also appointed through departmental written examination conducted and oral interview. 2, sir, I also hereby state that I regret that I had done, even though there was no intention to mislead. I beg before your authority that I have served in the village where there is no current, no easy communication for several years without regular salaries being paid by the government. There is no another chance for further recruitment since I already attended my age limit over age to be recruited in any other departments. 3, I also hereby admit that I am the only breadwinner in the family having no alternative source of income. If at all I am terminated, it would mean that my family would be left without any means of livelihood and my children would have to drop out from the school, which will amount that indirectly their future are being destroyed. I am also the only person to take the responsibility of my parents as well. I cannot even imagine how life would struggle if my plate of rice is being taken away. Therefore, I once again beg that I would not repeat the same and ready to pursue the professional course immediately as directed by your authority. So that is the
That is the admission.
and then the
What is 42 again?
42 is the order, the effective order, the penalty.
42.
This is also just the repetition of what we have already read. So I may be allowed to just take your lordships to the
Who
relevant
has
portion.
passed this order?
This is by the principal director.
Okay, this is the disciplinary authority.
Yes. He has recited the procedural part in
Yes,
the
please.
first page, page 42, and operative portion is page 43.
This order,
Paragraph-
page 42, let us read, Mr. Jamia, let us read.
Entire.
Let me also be conversant with your case.
Lordship, yes, I'll read. This is 8 June 2022 order. Whereas disciplinary proceeding under Rule 9, Clause 2 of the Nagaland Services Discipline and Appeal Rules 1967 were instituted against Srimati N. Menon, PT, GPS Puka, White Office Memorandum, 2nd March 2022, and the following article of charge. Article 1. That the said Srimati N. Menon, while functioning as primary teacher, violated Rule 4, Section 1, subsection Roman 1 and 3 of the Nagaland Government Servants Conduct Rules 1968. Statement of imputation of misconduct or misbehavior. Article 1. That the said Srimati Menon, while functioning as primary teacher, submitted fake diploma in elementary education certificate purportedly issued by the Mewar University, Rajasthan, has utilized the fake documents to mislead the department for availing undue service benefits, thereby fail to maintain absolute integrity and indulge in acts unbecoming of a government servant. The statement of imputation of misconduct or misbehavior on which the article of charge were based, together with the list of documents by which a list of witnesses by whom the charges were proposed to be sustained, were also forwarded to her along with the above said memorandum dated 2nd March 2022. 2. And whereas Srimati N. Menon submitted her statement of defense on 10th May 2022, wherein she denied to the articles of charge. 3. And whereas a 3-member board of inquiry was constituted to inquire into the charges framed against her under Rule 4, Clause 4 of the said rules by notification dated 14 March 2022. 4. And whereas the inquiry authority came to the conclusion that the article of charge is proved beyond doubt on the basis of careful analysis of evidences brought on record before it. 5. And whereas a copy of the inquiry report was sent to Srimati N. Menon, primary teacher, White Office Memorandum of Paper number dated 8 April 2022, and she has given an opportunity of making such submission on the inquiry report as she desired. She has also submitted her submission of inquiry report on 27/4/2022, wherein she had not raised any objection to the inquiry report. She apologized and sought pardon. 6. And whereas on careful consideration of the report of the inquiry authority and other records of the case, the undersigned has decided to accept the findings of the inquiry authority. 7. Now therefore, after considering the report of the inquiry authority and the facts and circumstances of the case, the undersigned has come to the conclusion that Srimati N. Menon willfully violated Rule 4, Section 1, subsection 1 and 3 of the Nagaland Common Servants Conduct Rules 1968, and the gravity of the offense committed is great in nature. 8. Now therefore, the undersigned is of the view that the ends of justice ought to be met if the penalty of removal from service, which shall not be disqualification for future employment under the Government Rule 7, Clause 8, of the Nagaland Services Discipline and Appeal Rules 1967 is embossed on her. The operative part of the order embossing penalty is issued separately. So the operative portion of the order is in the next page. This is issued on 8 June 2022. On the same date, in the next page, that is page 44, annexure O. The removal from service order is also issued. May I read?
Yes, please.
This is the same date, that is 8 June 2022. In continuation of this office order of appeal number dated 8 June 2022 and in pursuance of sub rule 10 of rule 9 of the Nagaland Services Discipline and Appeal Rules 1967, it is hereby ordered that Srimati N. Manon, primary teacher, GPS Pukamo, is removed from service under the Department of School Education, Nagaland, with effect from the date of issue of this order. This order of removal of service shall not be disqualification for future employment under the government, that is clause 7 of rule 7 of the Nagaland Services Discipline and Appeal Rules 1967. So against the penalty, petitioner has filed an appeal before the Commissioner and Secretary. You will find it page 45, annexure P. This is an application. In short, appeal. May I read, Lordship, from the body of the letter only? Respected Madam, I with due respect and honor hereby lay down the following grievances before your authority for necessary action and special consideration from your kind hand. That, Madam, as you are aware, I was terminated from a primary teacher post, white order number so-and-so, and thereby I am very much depressed and grieved beyond measure. I am of the opinion that I write this humble appeal before your concerned authority to reconsider the matter on humanitarian ground. I was appointed through departmental examination in the year 2013 and had served till 2022 with utmost sincerity and best ability. Madam, it is very unfortunate on my part that I have been fooled and victimized in obtaining professional course without proper channel, which we deeply regret and apologize to the department and your court self. I beg your pardon that the court self will consider my humble apologize and reconsider my reinstatement on humanitarian grounds, especially considering the future of my children who already started schooling. If no opportunity is given, it would amount that the justice has been denied after so much of seeking forgiveness. I have also attained overage while serving as primary teacher and therefore no other opportunity to avail employment in any other department. Therefore, please consider my appeal. Madam, I also beg that my services rendered for so many years without regular salary in remote villages where there is no current, no easy communication may also counted and value. I have served the department faithfully and sincerely in executing our duty as any other teacher. Some of the schools have few teachers where the ratio of teacher and student exceeds students. My termination has also deprived the rights of student as I am to leave the course unfinished. Madam, it is also pertinent to mention that I am parents to our minor children who are school going. I am the only bread earner and dependent of my family, having no other alternative means of livelihood for survival. My termination has been the darkest phase of my life, means of survival. Not only means of livelihood are being deprived, but also the future of our children are being denied and deprived as well. Therefore, Madam, there is no other great things than to apologize and beg your mercy. Please consider my representation and reinstate me in the same post for which I shall remain ever faithful and grateful for your kind gesture shown at this time of grief. So the petitioner has signed. Department was gracious enough to again respond and reply by a letter on 12 September 2022 at page 47, annexure Q.
Yes, please.
Page 47. An application of humble appeal to so and so. Madam, inviting reference to the subjects headed above, this is to inform you that I have gone through your application of appeal dated 15 June 2022, seeking for appeal against the order bearing number so and so dated 8 June 2022, passed by the disciplinary authority. You are well aware that you cannot blame the department by submitting fake and forged certificate documents, which are offenses of both civil and criminal nature. Further, the disciplinary authority, on the basis of careful analysis of evidence brought on record, decided to impose the penalty of removal from service without disqualification for future employment with effect from 8 June 2022. After overall consideration of the materials on record and in view of the disciplinary authority's finding and decision, I am not inclined to substitute the finding of the disciplinary authority and its report in any manner, and would not like to interfere with such conclusion which has been derived after scrutiny of relevant records and after giving full opportunity to defend yourself. Hence, order 8/6/2022 is confirmed. This is the removal order which has been confirmed. That is
against the order passed by the disciplinary authority. The appeal was filed, correct?
Yes, correct.
And this is the order passed in appeal.
Yes.
This is in the form of a letter. So by this letter, the appeal was rejected.
Yes, and confirm the removal order of 8 June 2022.
Yes, please.
Prior to these cases, there were two cases that is pertaining to graduate teachers.
Private teachers.
Graduate teachers. Graduate subject, two cases were filed, and this honorable court was.
Now, let us first complete this.
Yes.
Let us first complete this petition.
Yes.
After that, we will come to.
So that is the case. Now, by failure come there, the government has refuted what is there in their charge. But I would just like to refer.
No, what is the illegality in the findings of the disciplinary authority as well as the appellate authority?
Yes.
Yes, you can
That
satisfy
is
this court.
that is the most relevant question in our context. The penalty which has been imposed on the petitioner on 8 June 2022. This is the order of removal from service. And Lordship is well aware. When you impose the penalty, major penalty, because under Rule 7, which are minor penalties, which are major penalties, the procedure to be followed for imposing major penalty is totally different from the procedure for the minor penalties.
because the consequences of imposing major penalty is very, very serious. Therefore, the authorities should also be very, very careful while conducting the inquiry, because you are depriving the future and ruining the life of a future of a person. Therefore, inquiry should be meticulously conducted strictly in accordance with the procedures and the rules and the law laid down by the ethics court. Lordship is well aware. The principles of natural justice, auti alteram partem. The principle of auti alteram partem is very, very important in a case like this. The authorities, I'm not going into so many nitty-gritty and many details. Only one simple point, that is the respondents, they are saying that the petitioner was given an opportunity of being heard. Full opportunity has been afforded to the petitioner. That is the specific contention taken by the authorities during the inquiry, and in order to arrive to the major penalty, they have stated that, and in the affidavit also, they have stated that. In paragraph 10 of their affidavit, that is the category, there is a categorical statement.
No, Mr. CT.
Lordship.
In your case, how do you say that natural justice was violated?
Yes,
Yes,
that is what
kindly, in your statement.
that is what I am submitting, Lordship. They are saying. That is why I wanted to refer to the paragraph 10 of the government affidavit. They are saying that inquiry has recorded the statement of the petitioner, and all materials, documents relating to the case was also summoned and examined. That is the contention. Now, if at all, as they are saying, if the statement of the petitioner is recorded, definitely there will be some evidence, and the inquiry authority is supposed to examine all this. Disciplinary authority ought to have examined all this, because I'm again and again complaining, appellate authority ought to have examined. There are two stages, Lordship is well aware. Disciplinary authority, they have imposed. Ultimate forum is the appellate authority in respect of the petitioner, that is the commissioner and secretary. Had he inquired all this? That yes. No record. If they are saying that the statement had been recorded, show at least what was the question, what was my answer, and the petitioner himself should also get an opportunity to cross-examine the persons, the witnesses who are deposing against me. At least I should also be given an opportunity to cross-examine. But only a set of questionnaire has been placed, and then we were asked to reply that. And on the basis of that, they have arrived to the conclusion. And Supreme Court says that no, in a inquiry where the major penalty is to be imposed, full opportunity should be afforded. Even the person, delinquent officer, should be afforded an opportunity to examine the documents. If they are saying the fact, then I should get an opportunity to cross-examine also on that issue. Secondly, they have not recorded our statement. They are saying, if at all it is there, show from record. What was the query put on me during the inquiry, and what was my answer? Just a questionnaire was placed, and then you respond to this, and we'll conclude the inquiry.
Getting this proceeding against you is that you have actually submitted fake documents. You have submitted fake documents. And on that basis, the inquiry was proceeded against you.
Yes.
Correct. Now, there may be some minor technical lapses, but the fact remains that you have admitted that you have submitted a fact certificate ignorantly. So how do you overcome that? Let us forget, for some time, let us forget about that technical aspect. Of course, the punishment imposed on the petitioner is harsh, but the fact remains that you have actually submitted the fact certificate and you have admitted to that. Let us wriggle out of that first.
On that point, I was referring, having learned from reliable sources, I applied, and then I have undergone and obtained the certificate. But it's not intentional. Unintentional mistake was committed. That to that extent I have admitted, yes, it is an unintentional mistake have been committed. So for that I may be pardoned. Those things are in record, on record, so I cannot deny that also. But then my intention was not to cheat the government or to get undue benefit out of the service rendered to the government. In good faith, I have undergone. It was unintentional, and I did not have any knowledge about the fake university. So I obtained and I placed.
Yeah, let us see that citation which
Yes,
you were.
Lordship. I will only cite 3 citations. All the incriminating documents which are to be used
Yes,
against me.
let us see if that can satisfy this court. Because up to now, I am still not very convinced.
Hopefully, this judgment will convince.
Yes, yes.
It talks about affording full opportunity to be heard. (2010).
Just wait, Mr. Sethi.
Lordship.
You were also mentioning about the 2 cases passed by this court. You were mentioning about 2 cases passed by this court.
Yes.
This is also included here.
Interim order has been enclosed, but the final order has been passed
Yes.
in one of the cases where the writ petition was allowed, but directed the department to initiate fresh inquiry, and the inquiry is going on. And I have one additional prayer, Lordship.
Yes.
In the event of allowing the petition, and in a case like this, normally the employees are given an opportunity to avail the required educational qualification within a specific time. If they can, they are considered. Otherwise, they are thrown out because rule do not permit to hold the post by a unqualified person. Lordship. So if such an opportunity is afforded, insub justice will be met, Lordship, to all the parties.
Yes, please. Which
2010 to ACC.
Just wait, 2010 to ACC.
772.
Any.
Paragraph 19. Starting from paragraph 19, few paragraphs are referred. All are relevant and important, Lordship.
Yes, para 19.
Para 19.
Yes.
May I read, Lordship?
Yes.
Upon due consideration of the extensive pleading of the parties, the division bench has recorded the following conclusions. After hearing the rebel submissions of learned counsel for the parties as well as the awareness made in the affidavits, we are of the view that the inquiry officer has not afforded opportunities to the petitioner insofar as he failed to supply the documents to the petitioner which he has relied while framing the charge, and further, the petitioner was not afforded an opportunity to lead the evidence and also denied the opportunities of cross-examination of the person. The inquiry officer has owned the inquiry proceedings by recording any evidences. Thus, the inquiry is vitiated and is in violation of the principles of natural justice. With these observations, the writ petition has been allowed. The appellant has been directed to reinstate the respondents with all consequential benefits. However, the state has granted liberty to conduct fresh inquiry in accordance with law and principles of natural justice. And paragraph 29. Para 29 again. 29, 30. Paragraph 29 has the lordship correct? Yes. Apart from the above, by virtue of Article 311, Clause 2 of the Constitution of India, the departmental inquiry had to be conducted in accordance with the rules of natural justice. It is a basic requirement of the rules of natural justice that an employee be given a reasonable opportunity of being heard in any proceedings which may culminate in punishment being imposed on the employee. 30. When a departmental inquiry is conducted against a government servant, it cannot be treated as a casual exercise. The inquiry proceedings also cannot be conducted with a closed mind. The inquiry officer has to be wholly unbiased. The rules of natural justice are required to be observed to ensure not only that justice is done, but is manifestly seen to be done. The object of the rules of natural justice is to ensure that a government servant is treated fairly in proceedings, which may culminate in imposition of punishment, including dismissal, removal from service. This is our case. Removal is our case. And paragraph 34. This court in Kashinath Dikshita versus Union of India had clearly stated the rationale for the rule. Inquiries of the documents sought to be relied upon by the authorities to prove the charges leveled against the government servant. In that case, the inquiry proceedings had been challenged on the ground that non-supply of the statements of the witnesses and copies of the documents had resulted in the breach of rules of natural justice. The appellant hearing had requested for supply of the copies of the documents as well as the statements of the witnesses at the preliminary inquiry. The request made by the appellant was in terms turned down by the disciplinary authority. And paragraph 36 to 39. Paragraph 36, Lordship. Paragraph 36. Paragraph 36 to 39, may I read, Lordship? Yes. On an examination of the facts in that case, the submission on behalf of the authority that no prejudice has been caused to the appellant was rejected with the following observation. Be that as it may, even without going into the minute details, it is evident that the appellant was entitled to have an access to the documents and statements throughout the course of inquiry. He would have needed these documents and statements in order to cross-examine the 38 witnesses who were produced at the inquiry to establish the charges against him. So also, at the time of arguments, he would have needed the copies of the documents. So also, he would have needed the copies of the documents to enable him to effectively cross-examine the witnesses with reference to the contents of the documents. It is obvious that he could not have done so if copies had not been made available to him.
Taking an overall view of the matter, we have no doubt in our mind that the appellant have been denied a reasonable opportunity of exonerating himself. 37. We are of the considered opinion that the aforesaid observations are fully applicable in the facts and circumstances of this case. Non-disclosure of documents having a potential to cause prejudice to a government servant in the inquiry proceedings would clearly be denied of a reasonable opportunity to submit a plausible and effective refutal to the charges being required into against the government servant. 38. The proceed proposition of law has been reiterated in Tirloknath versus Union of India, wherein it was held that non-supply of the documents amounted to denial of reasonable opportunity. It was held as follows. Had he decided to do so, the documents would have been useful to the appellant for cross-examining the witnesses who deposed against him. Again, had the copies of the documents been furnished to the appellant, he might, after perusing them, would have exercised his right under the law and asked for an oral inquiry to be held. Therefore, in our view, the failure of the inquiry officer to furnish the appellant with copies of the documents such as the first information report and the statements recorded at the Shitipura house and during the investigation must be held to have caused prejudice to the appellant in making his defense in the inquiry. 39. The proposition of law that a government employee facing a departmental inquiry is entitled to all the relevant statements, documents, and other materials to enable him to have a reasonable opportunity to defend himself in the departmental inquiry against the charges is too well established to need any further reiteration. Nevertheless, given the facts of this case, we may re-emphasize the law as stated by this court in the state of Punjab versus Pakat Ram. 6. The state contended that respondent was not entitled to get copies of statements. The reasoning of the state was that the respondent was given the opportunity to cross-examine the witnesses, and during the cross-examination, the respondent would have the opportunity of confronting the witnesses with the statements. It is contended that hypnosis was adequate to acquaint the respondent with the gist of the evidence. The meaning of the reasonable opportunity of showing cause against the action proposed to be taken is that the government servant is afforded the reasonable opportunity to defend himself against charges on which inquiry is held. The government servant should be given an opportunity to deny his guilt and establish his innocence. He can do so when he is told that the charges against him are. He can do so by cross-examining the witnesses produced against him. The object of supplying statements is that the government servant will be able to refer to the previous statements of the witnesses proposed to be examined against the government servant. Unless the statements are given to the government servant, he will not be able to have the effective and useful cross-examination. 8. It is unjust and unfair to deny the government servant copies of statements of witnesses examined during investigation and produced at the inquiry in support of the charges leveled against the government servant. As hypnosis does not satisfy the requirement of giving the government servant a reasonable opportunity of showing cause against the action proposed to be taken. So the proposition of law is very clear. Here,
proposition
it
of law is okay.
categorically states about
How
this
was natural justice
statements.
violated in your case? How was natural justice violated? Let me just have that short answer.
To reply precisely, in paragraph 10 of the affidavit and also in all the documents, the respondents has said that the statements of the accused has also been recorded. That means they are trying to project in such a way that full opportunity was given to the delinquent officer. But then there is no record to show. And our contention is that during the inquiry, we were just given a sheet of paper with a few questions, questionnaire that was asked to be answered. And that was taken as an evidence so as to impose the major penalty. That way, the principles of natural justice has been violated, Lordship.
You are referring to which para of the government's affidavit?
Paragraph 10. And since I'm referring to the paragraph 10 of the government affidavit, in my reply, I have filed reply to the government affidavit. Paragraph 4, 5, 6, and 7, only 4 paragraphs. There I have stated everything.
Okay, Mr. Siti. Okay. Admitting that there is violation of natural justice, okay, in the case. How do you overcome the admission of the petitioner that he or she has submitted fact certificate? How do you overcome that?
Lordship.
Because actually the technicalities, I think.
From day one, I was saying that I do not know whether it is fake or genuine, but I submitted as a genuine document. But authorities, they are coming with a contention that no, your certificate is fake.
That is on the basis of the report submitted by the university.
Therefore, whether it is fake or genuine, am I not entitled to get an opportunity to examine in detail on all those points? That is my case, Lordship.
You yourself has waived that by admitting. You yourself has waived that by admitting that the documents which I have submitted is fact. See.
I believe I have not stated that which is alleged to be fake.
No,
That is
no.
that word I have used.
We will see
They
your.
are saying,
We will see your
respondents are saying
petition.
that it is a fake. That's why alleged to have been fake.
You have even sought apology by submitting that you have ignorantly submitted fact certificate.
Bargaining power between the employer and the employee is totally different. I'm an employee, a humble government servant.
In matters of a fact certificate, the question of bargaining power will not arise. If you have submitted a genuine certificate, that question will not arise. If you have submitted a fact certificate, the question of bargaining power will not arise.
Lordship, bargaining power to the extent that you have already apologized that as a humble government servant, I'm at the receiving end. The only way I can appeal to the authority is to seek an apology only. Otherwise, that is why the bargaining power is more with the authority than the employee.
Had you submitted a genuine certificate?
I believe it to be genuine.
Will you ever accept the contention of the government that this is a fact certificate? Will you ever accept that contention or the stand of the government? No. But the stand taken by the government is that you have submitted the fact certificate. And you have admitted, yes, I have submitted a fact certificate and therefore for that I may be apologized. And I may be allowed, the opportunity to pursue that.
Believing it to be genuine, I submitted. That is my contention. Alleged to have been fake, that language I have used. Because they are saying that you have submitted.
In your application, in your petition, you must have used that word, but not in the petitions, in the application submitted by the petitioner. Anyhow, we are recording.
I don't remember to have submitted the fake certificate. Next citation, Lordship, 2017, 2 ACC, 308, paragraph 7.
2017, yes.
2 ACC, page 308.
Yes.
and paragraph 7, Lordship. The only one paragraph.
Para 7. Yes.
May I read, Lordship?
Yes, please.
We have given our anxious consideration to the submissions at the bar. It is true that a writ court is very slow in interfering with the findings of fact recorded by a departmental authority on the basis of evidence available on record. That is what Lordship is coming with. But it is equally true that in a case where the disciplinary authority records a finding that is unsupported by any evidence whatsoever, or a finding which no reasonable person could have arrived at, the writ court would be justified, if not duty bound, to examine the matter and grant relief in appropriate cases. The writ court will certainly interfere with the disciplinary inquiry or the resultant orders passed by the competent authority on that basis, if the inquiry itself was vitiated on account of violation of principles of natural justice, as is alleged to be in a position in the present case. Non-application of mind by the inquiry officer or the disciplinary authority, non-recording of reasons in support of the conclusion arrived at by them are also grounds on which the writ courts are justified in interfering with the order of punishment. The High Court has, in the case at hand, found all these infirmities in order to pass in by the disciplinary authority and the appellate authority. The respondent's case that the inquiry was conducted without giving a fair and reasonable opportunity for leading evidence in defense has not been effectively refuted by the appellant. More importantly, the disciplinary authority does not appear to have properly appreciated the evidence on recorded reasons in support of his conclusion. To add insult to the injury, the appellate authority, instead of recording its own reasons and independently appreciating the materials on record, simply reproduced the findings of the disciplinary authority. That is what it has been exactly done in our case also. All told, the inquiry officer, the disciplinary authority, and the appellate authority have faltered in the discharge of their duties, resulting in miscarriage of justice. The High Court was, in that view, right in interfering with the orders passed by the disciplinary authority and the appellate authority. And lastly, 2021 ACC Online, Supreme Court 995, para 9.
This para 9.
Yes. This is on general principle.
Yes, yes.
Para 9.
Yes, please.
A departmental proceeding against a delinquent is a serious matter, as it has its repercussions which can be far-reaching. It is straight law that departmental proceedings are quasi-judicial proceedings. The inquiry officer functions in a quasi-judicial capacity. He has a neutral role to perform and cannot act as a representative of the management. He has to act as an independent and impartial officer to find out the truth. The major punishment awarded to an employee visits serious civil consequences, and as such, the departmental proceeding ought to be in conformity with the principles of natural justice. Even if an employee prefers not to participate in inquiry, the department has to establish the charges against the employee by adducing oral as well as documentary evidence. The case charge warrant major punishment. Then the oral evidence by producing the witnesses is necessary. The question of any cross-examination by the delinquent arises subsequent to the charge having been prima facie established in accordance with law. If the charges are not established in accordance with law, there is nothing for the delinquent to deny. Reference may be made to so and so. So generally, Lordship, it is not necessary that employee should put the question or this and that. An authority cannot just say that, oh, the delinquent officer is not raising this issue, that issue. Let us just ignore and then go ahead with the
basing on the finding of the inquiry report and all this. But complete and full opportunity is required to be afforded, even if the employee do not raise any query in question on the procedural aspect of the matter. So this is the mandate of law, and I'm praying that the respondent has miserably failed to follow the dictates of law. Therefore, the ambient orders are liable to be quashed. I have been referring to the two other cases. Out of the two cases, one is here, that is the second item, that's item 50, Alila Imsong. And the other one, Ausana, that has been taken up for hearing and then allowed the writ petition by quashing the ambient orders, the similar orders. But the department was given liberty to conduct a fresh inquiry in accordance with law, and that is in the process, that is going on. So, Lordship,
This writ petition 112, which you have placed before the score. And this WPC 112 of 2022.
Lordship.
This was also on the same set of facts.
Yes. In the similar line. But one vital mistake what the authority has committed was in the charge, which was served to the petitioner.
In which case?
In this WPC 112, which is decided, name of Alila Emsong is mentioned. Whereas penalty was imposed on Ausana. Absolutely non-application of mine. That means what they have done, Lordship, authority has done, since the cases are similar, in respect of all, similar charge was framed, in respect of all the employees, and it was served. So also during the inquiry, questionnaire was prepared, and then it was served, you respond to this, you reply to this. That is how they have conducted. And while filling up the forms,
this is from the Swami Vivekananda University.
yes.
Yes, Mr. Angami, if you have not appealed against this order, I think this is the same line this court has to adopt.
Lordship, in fact, here in the 112, principles of natural justice was violated on the ground that in the inquiry report, inadvertently, the name of the petitioner was not reflected, and the name of the petitioner in the WPC 114, which is pending before this court, was actually inserted there. A clarification thereafter was already given, but the court has taken into consideration that the clarification that was given by the department thereafter, an opportunity was not given to the petitioner to reply on that particular clarification letter, and that violates the principle of natural justice. That is what the court has mentioned in para 25 of the order.
So what you mean to submit is that the fact situation in this case and the present case?
Yes, it's different, Your Lordship.
Okay, you satisfy this court on that.
Lordship.
Mr. TB, I think we will have to continue next time.
Not sure. Tomorrow?
Tomorrow, it will be a very difficult day for this court. Because tomorrow we are having a core committee meeting.
Lordship.
That is under construction?
Yes, you have received the notice.
Yes.
You are
But-
also a member of that.
Regarding the appointment, I have received the notice, but with regard to the tomorrow's meeting, so far I have not received.
Are bhai? I don't know what the registry.
Maybe they may have given it through software. I am alien to such latest technology.
Of course, I am also with you on that. But,
As convenient, your lordship, as convenient.
Any date convenient to your lordship. And so far as my submissions are concerned, lordship, I think that will be sufficed, and I will furnish it, lordship. Showing the different rate petitions, name, year of appointment, name of the post, educational qualification, from where certificate was obtained. So that it will be easy for lordship. And it not go to the other facts in the other cases, because the charges are similar in all the cases.
This B.Ed degree issued by South Christian College, this is not recognized.
This is recognized.
The way it is B.Ed 2013 South Christian College, Nagaland University.
Recognized, but then there was some discrepancy in the certificate.
Means this South Christian College, Nagaland University has issued you the certificate.
South Christian College has issued the certificate.
So what is the discrepancy then?
Discrepancy, like against one roll number, two certificates were issued, something like that. Otherwise, South Christian College is a recognized
That's
institute where B.Ed course can be availed.
So basically, the stand of the government was that the certificate which you have furnished is fake,
Yes,
not the university.
yes.
Maybe I think you have made your submission, but in your cases, I think I will have to request you to take me to your petitions one by one. Just to get the
Lordship,
facts.
I'll do that. And the reply, lordship, may kindly take note of paragraph 4, 5, 6, and 7. Only 4 paragraphs of my reply to the common affidavit in this particular case.
Paragraph?
Paragraph 4, 5, 6, and 7 of reply to the affidavit.
Paragraph 4, 5,
6, and 7.
6, and 7 of reply affidavit.
Yes. Against the affidavit of respondent number 1, 2, and 3.
So I think we can have it only after the vacation. Because the after tomorrow is the last working date. What about 25?
Yes.
What about 25, Mr. Chief? Separate? It's okay. Give this part one file to me. The next date fix, you just repeat part two. No, not all this. Heard Mr. C.T. Jamir, learned counsel, assisted by M.S. Sunso.
Krobit Sakru.
Learned counsel for the petitioner in WPC 251/2022, WPC 114/2022, WPC 252/2022, WPC 253/2022, WPC 254/2022, and WPC 255/2022. And Mr. T.B. Jamia, learned counsel for the petitioner in WPC 259/2022, 260/2022, WPC 261/2022, WPC 262/2022, WPC 263/2022, WPC 264/2022, and WPC 265/2022. And Mr. Enangami, the learned senior government advocate for the state respondents. The hearing remains inconclusive, listed as a powdered item on 25/7/2024. This way you keep it. This simple.